leave meeting. This meeting is being a live stream.
All right. Good morning again. This is the call of it's actually a 3-week trial calendar. It said 2, but we actually are going to have 3 different weeks for juries. Doesn't start till after Thanksgiving. So today we're calling the calendar to figure out which cases are ready, which cases may resolve short of trial, and the order in which I'll call cases out on the 3 weeks. For your purposes, your scheduling purposes, the first week of jury selection and actual trial is the week of November 28th. So that's the Monday after Thanksgiving. We will have a trial starting on that day. We'll pick a jury that day. The next week, the calendar says the 6th. That's technically our day to get jurors, but I've managed to get a spot on the 5th. So that following Monday, December 5th, we will be able to pick a jury, assuming we're done with the trial we started November 8th. So we'll have a second jury trial. And then finally, the week of December 12th, we will be able to get jurors again in here for hopefully a 3rd jury trial. I don't expect anyone, meaning lawyers, to go back to back to back. That's not how we're structuring this. So part of what we'll be working through today is who can be ready 1 week, the expectation that if you try a case week 1, then I won't be expecting you here week 2. Maybe week 3, you have a week to recover. But hopefully we can resolve a fair number of the cases that are on this trial calendar. So those are the 3 weeks. And I know some of us have talked about this before, but as of Halloween, we shifted the way in which we do jury selection. That will occur in this courtroom, not down in 1C or 1D. We pick juries in each judge's courtroom, and we have the ability to get jurors the next day if I call in case X and at noon, a defendant decides, you know what, I think I'd rather work this case out and enters a plea. Okay, then the next day we can bring in jurors to try to move the next case that we lined up for that week. So with that, let's figure out who is ready and what we might be able to do with these cases. Position 1 is Brian Carr. Mr. Carr, are you here?
I'm outside at the moment to talk with his lawyer.
Okay, and you are?
I'm his best friend.
His best friend. All right. Well, let's get Mr. Carr in here and we'll figure out what we're going to do. Hey, Mr. Carr, how you doing? Is your lawyer out there? There he is. Excellent. So position number 1, a case we will resolve on this trial calendar is State versus Brian Carr. Mr. Hand, you ready to go with this one?
Yes, Your Honor, the state is ready.
Great. You guys are coming all the way up to the podium. This is official. How are you, Mr. Cruz?
Good morning. I'm doing well, Your Honor. And
Good to see you.
Honorable Court. Pleasure to see you as always.
So you missed the announcement. You were out there talking with your client, but I was just explaining that we've got 3 different weeks to have trial: November 28th, December 5th, December 12th. And Mr. Hand has just announced in your presence that the state's ready to proceed. At long last, we have the alleged victim, Mr. Owens, in pocket. That was one reason, the main reason we kept having to continue this case. You've been ready. Mr. Carr's been ready. But now we have the pieces in place if it's going to be a trial. So Mr. Hand's announcement is ready. What's yours?
Well, Your Honor, just to put this on the record, if Mr. Hand is the attorney handling the case now, I wasn't aware of that. We've reached out consistently to the prior prosecutor, Ms.
So there could have been Ms. Hall, and then it would have been Ms. Charles.
Ms. Charles. We have not, and we've reached out via phone call. We've reached out in writing. We have not received a response.
Okay.
Mr. Hand being the prosecutor on this case is news to me.
Great.
Last we spoke to Ms. Charles, we're in the process of coming to a resolution to this case, but communication ceased. And I don't know if that's because Mr. Hand is now handling the case. And if that's the,
To be clear, he's handling the case.
yes, sir.
No questions about that. And my experience thus far has been that Ms. Charles has very effectively communicated, here's where I was with attorney X. We were close, we were far. Mr. Hand has not been the kind of prosecutor who says, I don't care what Ms. Charles's offer was. There's a new sheriff in town and Mr. Carr can take 50 years or we'll see you in court. I don't think that's how it will go.
Yes, sir.
And what I'll ask is that you and Mr. Hand have a conversation this morning about where he is, and you can get him up to speed as to where you think Ms. Charles and you were.
Yes, sir.
And I suspect you guys will be able to pick up not too far off wherever you think you left things.
Yes, sir. Now, at this point, because me and Ms. Charles were in the process of trying to figure something out, we never got to that final conversation with the conclusion. I would ask the honorable court is willing for a continuance, but I will stay behind to talk to Mr. Hand today.
Okay, so no to the continuance. Here we are on November 8th, and the first day this might go to trial is 20 days, 3 weeks from now. So plenty of time. One, to keep up the negotiations, and two, to be ready to go. You have told me several times in the past, you're ready, and Mr. Carr is ready, and he is understandably tired of this thing hanging over his head.
Yes, sir.
And it was not his issue or yours that Mr. Owens was unavailable. He was stuck in federal custody in Florida. It's a state issue and not a defense issue. So we will resolve Mr. Carr's case during the course of this trial calendar, but we've got over a month.
Yes, sir.
Because that next, if the week of December 28th is somehow too soon, then we would do the week of December 5th. If it's going to be a trial, but it may well be that this is something that works out with a negotiated plea. So my direction is that you and Mr. Carr stay. And then I want to get a report back from you, Mr. Cruz, and you, Mr. Hand, as to, it looks like it'll work out, but because it's not working out today, which is all right, we, the lawyers, would like the week of the 28th, which is what Mr. Hand had indicated he could be ready for.
Yes, sir.
And you may say, you know what, I was trying to get ready, then I didn't know if I needed to. I couldn't find Ms. Charles. So maybe I, Mr. Cruz, would like the week of December 5th. I'm open to that, but you all should discuss that first.
Yes, sir.
Okay?
Yes, sir.
Mr. Hand.
Yes, if I can say, Judge, I don't want to start a back and forth, but I do want to say for the record that September 7th, Ms. Charles, the previous ADA, did reach out to Mr. Cruz and tell him I was the new ADA taking over the case. I reached out as well via email, the same chain that he replied to her on, never received a response. So
That's why it's great the two of you are going to get together today, because we aren't going to have in front of everyone else the back and forth. I'm confident that you did reach out. You have followed up with Ms. Charles's cases as you've inherited them. I'm also confident that Mr. Cruz has been trying to reach Ms. Charles, because that's what he said. And so maybe he missed your outreach, or was like, whose Hand? I'm dealing with Charles. Don't know, but now we know. Cruz, Hand, Cruz. Let's figure out where this case might go. If it needs to be a trial, let's do it, because we've got Mr. Owens biding his time at the Fulton County Jail
Yes, sir.
until we can get a resolution on this one. Okay?
Yes.
So after you guys, you don't need to wait till the end of the call of the calendar. You're going to need to wait because Mr. Hand stuck through the rest of the call. But once you all have reached a sense of where this is going, just give me that report, and then I will gladly excuse you, Mr. Cruz, and you, Mr. Carr, for today. Once I know, all right, so I'll be seeing you guys on Monday, the 28th, ready to go to trial if it hasn't been a plea before then.
Yes, sir.
Okay?
Yes, sir.
Great. Mr. Carr, any questions about any of that?
Sure.
All right, you got a good friend here. When I called your name and you weren't here, this guy stood up and said, no, my guy's here. All right, I'll talk to you guys soon.
All right. Thank you, Your Honor.
You're welcome. Position 2, Ryan Williams.
You know, Mr. Williams woke up this morning with a fever and not feeling well and asked if he could appear via Zoom. I told him he could not, and he said he's on his way.
Oh,
So it's a late start, but I do expect him here.
okay. So if someone's ill, I'm all right with a Zoom appearance rather than him coming on in here. So I don't know how close he is, if he's still closer to home than here, and he wants to turn around and keep his fever at home, that's okay. You erred on the side of caution. This guy is on bond with some pretty serious charges, and so eyeballing him is a good thing, but it sounds like he is alive. I won't say well because of his description to you. And that's the key part, is that you and he are in communication, because this is one that will likely be at the tippy top of one of the trial lists. So if he does show, maybe he can just darken the doorway. My recollection is that Mr. Abate had said this would be a good number 2 to Ms. Boyd. If Ms. Boyd was specially set, she's not on this calendar. She'd be added to the week of the 12th. If she were specially set, because that way we could get Mr. Johnson here for sure. And the gang unit has always said that the Boyd case tries itself. And so I was viewing Mr. Williams as perhaps being the backup to Ms. Boyd in case it pled out the week of the 12th. Doesn't have to be there. Did you have anything changed as you were thinking about things, Mr. Abate?
No, Your Honor, anything for the state.
Okay, I know there was the Dr. Sperry situation. Any update on that?
Yes, Your Honor. And I've spoken with Mr. Williams about this, but essentially we're still going round and round about this. So Mr. Abate sent me the physical therapy reports last week. I sent them to Dr. Sperry and reiterated what Mr. Abate said about there being no other medical records.
Right.
He immediately emailed back and said that according to the autopsy, there should be records from Grady because he was transported there by a Grady ambulance and stayed there for like 24 hours. And so he was very adamant that he needs to have everything the medical examiner had. So it does in fact say that he passed away at Grady. So there should be those records and tox reports and all of that. That would be obviously very important for us to have.
Okay.
We don't have them, so.
Right. It doesn't sound like the state has them either. And pre-you, I know Mr. Abate and investigators pushed Grady to hand over everything. So it may be that your team could ask Grady in a different way, and maybe that might cause something to be found. But I don't get the sense that the state has not tried to get all the records from Grady. I hear you loud and clear that Dr. Sperry is saying there's something out there. There was something out there at some point and he doesn't have it. And he ought to be able to assess, well, what was behind the death? Because if the toxicology is his blood alcohol level was 9 as opposed to 0.08, then that's what killed him. So I understand why he'd want that. I don't know how to get it for him.
And I think his issue partially also is that it appears to him that the medical examiner had it.
Yeah.
So if the medical examiner is going to be able to testify to it and he hasn't reviewed it, that's a problem.
Sure. What's been your outreach, Mr. Abate, to get, I know you always get the autopsy, but sometimes there's more, there's a file. Is that a stone that hasn't been turned over yet?
I got records from the medical examiner's office that I provided to Ms. Patel. So everything I went and personally copied the file.
They gave you their file, you copied it, you got it to Ms. Patel. So whatever you were able to get from the ME's office at one point went to the PD's office.
Yes.
Okay. Doesn't mean it's not there, but again, you may want to reach out to the ME's office to say, well, would the medical records associated with treatment at a hospital be outside of the medical examiner's file, but in a file somewhere? We'll see. It's sounding like, given that though, the week of the 12th is what you'd prefer.
Yes, Your Honor.
Okay. If there was going to be a week, which there needs to be because this case is really old. All right. Sherry Grant. Is Ms. Grant? I can't remember how we left. I know Ms. Grant's situation. I just don't remember what we communicated to you, Ms. Feely, to relay to Ms. Grant.
I have spoken with Ms. Grant since last week, and I was expecting her here, but the traffic issue could very well be the issue. And also,
She's coming from far away.
Rome, Georgia.
Okay. Which could be then impacted. I don't know where on 285 there was an issue, but why don't you, during a break, check with her just so we can have a check-in. And I guess there was a concern about her ability to focus given the newborn.
Right, and not be a distraction.
Right. Okay. Well, let's figure out what her situation is and we'll revisit that. All right, Landon Christopher. Right there. Hello, Mr. Christopher. Hello, Ms. Wood.
McBurney. If we could come back to this one, Mr. Han and I have been negotiating. I just need to speak to Mr. Christopher.
Great. Mr. Christopher, Ms. Wood's going to talk to you about a possible resolution. She may have received a new offer from the state. So I'm going to ask you to stick around until I get an update, because either we're going to work the case out today or we need to figure out which day we could tee this up for a trial. Okay? Thanks. John Fant, 2 cases. There's Mr. Fant.
Same announcement, Judge.
Okay, same deal. Ms. Wood's going to talk to you about maybe working your both cases out.
Yes, Judge.
Okay, great. If we don't, Mr. Hand, which of the 2 cases of Mr. Fant would you want to go out on first?
Position 6, Judge.
Okay. Thank you. Tiffany Singer.
Morning, Judge. Lauren Brown for Ms. Singer. I'd like to first inquire whether or not we know if she was produced today.
Was the female you brought up Ms. Singer?
I was
Okay,
gonna ask that, Judge. She had been committed to the Department of Corrections, maxed out, went to Douglas. She called me from Douglas. I went to try to find her. She was gone, and I have not seen her appear in full.
Okay.
I do expect this to be a negotiated plea. Whether we've gotten to the final resting point of that, I'm not sure, but that is my expectation.
okay. But we need to find your client.
We do, and I expect she's in the system somewhere. There were at least 3 or 4 holds when I first met her. She's resolved at least 3 of those. She could potentially be in Habersham, which is the only place I have not attempted to see her.
Okay. Yeah, I don't know that I've ever met her in person. I think it's always been, hey, reporting live from Clayton Jail, reporting live from, okay. But your understanding is that she is likely in custody.
Yes, sir. So she had 4 holds. I know she's resolved 2 of them at least. She would have a hold here in Fulton, and she potentially could be in Habersham.
Okay, because she has a bond here. It's a big bond, but she hasn't posted that bond.
She has not.
Okay, so when she's done with her other holds, you think she's coming back? That the plan would be, if the sheriffs all talk nicely to each other, that she'd come back here.
That is how it was supposed to work. Yes, sir.
Supposed to. Okay. You expect it to resolve, Mr. Hand. If for some reason it doesn't resolve, what week would you be ready to go?
The first week, Judge.
Okay. All right, Mr. Brown. So
Yeah, I would be ready, Judge. I mean,
Great.
I don't, there's no outstanding issues. I just don't expect it to require a jury.
sure, understood. So we'll have it on the list for cases for November 28th. Any resolution, trial or plea is contingent upon us finding Miss Singer. So we'll take your clue of Habersham, look around, see what we can find. And you don't need to stick around for us looking for Miss Singer. You've been easy to find. So we'll keep finding you. And ideally, if it's going to be a non-trial resolution, it would be someday before that trial day, so that we're focused that day, not on taking pleas, but picking a jury.
Great.
All right.
Yes, sir.
Thank you. Kiana Duncan. Hello, Ms. Duncan.
Judge, she's mine. If we
She
could
is.
Also come back to this one. I just sent Mr. Whitenar an email, so we'll be discussing this one.
Great. All right, Ms. Duncan. So same situation. It sounds like the lawyers are talking about your case, and then Ms. Wood's going to want to talk to you about that. So sit tight. All right. Thank you. Danny Jones.
Danny Jones is actually appearing virtually. He had a medical emergency last week, and he was discharged from the hospital on November 4th of last week. And he unfortunately is not very technology savvy, so he just took pictures of the records, which I sent to Mr. Hand. But
Okay.
in any event, this is one that if we could have a plea date in this month sometime, this will resolve.
Great. I can see Mr. Jones. He's on the screen right now. There's not an audio part of his feed. Can you hear us, Mr. Jones? Raise your hand if you can hear us. Yep. So he's not hearing us, but he's connecting to audio. Excellent.
I think that didn't work.
Okay. I don't know how text will, bye.
to get this far took a tutorial, Your Honor. So.
No, but it's great. I appreciate he's here, and it sounds like we just need to figure out a date to get him physically into, can he come to court? Or it would be
He's not with us now. But
Okay.
if he's on-
Later in the month, he might be able to come here. All right, well, why don't you reach out to Mr. Jones through another channel, let him know all is good. We saw him and we hope he gets well soon. And that if you would just work with Mr. Hand and Ms. Nelson, we can take a plea. Either we always have the 8:30 to 9 window before court starts, or lunch. I think I have a civil trial starting soon, but we can always before trial each day take a plea, or at lunch. And I think we've got a few criminal calendars between now and then. I have Mr. Jones down as being ready to go on the 28th, as in we could try it that first week, but now I'm hearing this is one that's going to work out. Is that your sense too, Mr. Hand?
It is, Judge.
Okay. All right. I'm going to send him one more text that he's free to go. See how he handles that. All right. That gets us to Delon Lumas. Was Mr. Butterfield one of the I'm turning arounds? His client's in custody. Yeah, okay. So we got to wait for Mr. Butterfield. We'll come back to that. All right. One second. All right, Tyler Montgomery.
Good morning, Your Honor. Ron Hood on behalf of Mr. Montgomery.
Hey, Mr. Hood.
How are you, sir?
I'm well. How are you?
I'm doing well, Your Honor.
There he is. I've got a note here about the ankle monitor.
I have a consent order that Margaret Pierce Hand needs to sign just for your consideration.
That will make it a county paid ankle monitor. Good. That was why I had it on here. Okay. But that doesn't resolve the case. Mr. Hand had told me he's ready to go. He was hoping maybe it would be second week, not first week. Where are we in terms of the defense side?
We're still discussing, Judge, but at Your Honor's direction, we'd be ready.
Okay.
Subject to ongoing discussions. I think you got an email last night with recommendation. I'll continue to discuss it, but if you want to call us in on the second week, we'd be ready.
Okay. Does that week still work for you, Mr. Hand?
Yes, Judge.
Okay.
Not learned it to hand, but yeah.
All right. So Mr. Montgomery, couple things. One, sounds like your lawyer is working with the prosecutor about trying to work the case out. In the meantime, I'll sign an order that shifts that ankle monitor that you've been wearing forever to one that is paid for by the county rather than you or your family. You may not have to be wearing the ankle monitor a whole lot longer if either you plead your case out or you go to trial, because if you're found not guilty, there goes the ankle monitor. If you're found guilty, you don't need an ankle monitor because you'll be going somewhere else. But we will have your case down for that second trial week of the 5th of December.
Should we report on the 5th now?
What's going to happen is that an email will go out to all the lawyers who have cases on those different weeks. And it'll show you the order in which I expect them to be called out. But every case that is on for that week does need to report here if it hasn't otherwise resolved. So that's the incentive to, before the 5th, figure out a way to resolve it, because showing up on the 5th and saying, now I want to plea, that's not what the 5th is for. The 5th is for, great, let's bring in 50 jurors, pick a jury and get rolling. Okay. So that'll be the week we put it on. Sure. Yeah. You guys talk about that. And then I'm happy to take a look. Kimberly Saxon. Hello, Ms. Saxon. Ms. Wood?
Judge, we would be ready. I do want to speak with her after the call to see if this can resolve today.
See if what?
If this can resolve today.
Today, okay. But this is one that we could try that first week, the week of the 28th.
Yes, Judge.
Okay, so Ms. Saxon, I'm gonna ask you to wait around until you and Ms. Wood talk. If the result of your conversation is we're not resolving things today, then I'll see you on the 28th of November here, this courtroom, and we can pick a jury in your case and have a jury sort out whatever allegedly happened in your case, okay? So please wait till Ms. Wood talks to you. Thanks. Christopher Coleman. There he is.
I need to speak with him and get some better contact information.
All right, that'll be step one. And then otherwise, you're ready to go that first week?
Discovery wise, it's ready to go, yes.
Excellent. Okay. So Mr. Coleman, I need you to stick around till Ms. Feely can get a good phone number or some other way to reach you and vice versa, so you can reach her, okay? And then your case will be one of the ones that we put in line for that first trial week right after Thanksgiving, if it's not otherwise resolved, all right? Thank you. Ms. Castillo, if you could unmute, please.
Hello, good morning.
Good morning, and we've got your attorney, Mr. Richardson. I think he's one of the people who encountered the parking lot on 285 and wisely returned to his baby blue office so we could talk about this case. Mr. Whitenauer, still your case?
Yes, Judge.
Excellent. So Mr. Whitenauer explained, oh, this is the one where it's co-defendants. Mr. Whitenauer is handling the part involving Ms. Castillo. Same case, Mr. Hand, you're handling the part involved, so it's sort of tag team. Mr. Cano, Santiago Cano. Is he here?
He is, Your Honor.
Hey, Mr. App, how are you?
I'm doing well. Good to see you.
So let's talk about both these together. There he is in the back. Excellent. Excellent. All right. So you guys can take a seat. Mr. Richardson, Mr. Whitenauer and Mr. Hand were hoping that if this was going to be a trial, it could be that last of the weeks, the week of the 12th December, but we've got 3 different weeks we could do. What works for you?
Either or, Judge. I thought Mr. Hand, I spoke with him earlier, said the 6th, but 6, 12, that matter to me.
Okay. Ms. Castillo, I understand that you have suffered a pretty serious dislocation of your household. Are you going to be able to work, though, with Mr. Richardson and be ready if it ends up that your case needs to go to trial?
I'll try my best, yes.
Okay, well,
Judge, I sent Ms. Nelson a picture. It seems like the whole house, the whole ceiling burned through, so she's seriously displaced.
No, I understand. I saw the picture, and it's real serious, and it's clearly something she's still working through, which is another reason why maybe having a trial towards the end, a month away, that's going to give Ms. Castillo a chance to get a little more stabilized. But I'm going to rely on you, Mr. Richardson, to keep Mr. Whitenauer and Ms. Nelson informed on how Ms. Castillo is doing, because if it is a trial, obviously you need her to be on point for you. And so we need to make sure she's in a good place.
Understood.
All right. While you guys are on, let's hear from Mr. App. Is Mr. Cano ready to go?
Your Honor, I think there's a couple items of discovery I'm not clear that we have yet. At the last calendar, which was, I think, a month ago, I had an associate here who indicated that we were still missing some body camera footage and a lineup card where my client was identified.
I remember a discussion about that, and the fact that the identification, if made, was by, I think it's Miss Castillo's husband, ex-husband, so it wasn't a stranger on stranger, but Mr. Whitenauer can address at least the lineup, but we need to make sure you've got everything you're entitled to, and everything you've described, you're entitled to.
I think there was also a search warrant and a phone dump from Miss Castillo's phone that we applied as well. So those are the three items.
All right, thank you for categorizing them. So lineup, I think it may have been a single photo. I think that was my recollection, but we'll hear about that in just a moment. Body cam footage and phone extraction.
Correct.
All right, what says the state?
So Judge, I had an update from my investigator that the body cam video was in the mail to our office. So I'll be able to produce that to defense counsel.
And what's your understanding of what that officer is doing that makes the body cam relevant? It's interacting with the alleged victim, or it's the arrest of Mr. Cano, or what is?
I don't know.
You don't know.
I haven't viewed it, Judge. I'm sorry.
Okay.
As for the photo lineup or admonition and the Verizon records, I, after that last hearing, did request my investigator to receive the update that I received from her, did not provide information about that. So I followed up asking about those two items. So it was for that reason at that last calendar that we did ask this be set for December 12th so that we could produce that.
Got it.
And then also, given these extenuating circumstances, that might make additional sense.
Sure.
But I will, after this calendar, work on those two remaining issues, the photo lineup, admonition, and Verizon records.
Okay, and so Mr. Apt and I can be clear. Verizon records sounds different from a phone extraction. Are you aware of whether there was a phone extraction, or your understanding is, and people may have just been sloppy in their terms, there's no phone extraction, it's phone records obtained from a cell provider, or it's both, or neither?
I'm unaware of a phone dump, Judge, but I will speak with the detective about that to make sure that if there is one, that is also provided to defense.
Sure. Okay. So Mr. Apt, it sounds like more materials are coming your way. I think the nature of our conversation with your associate and Mr. Whitenauer was you are 100% entitled to that. None of that is game changer stuff. You'll be the judge of that. So if you get some of that and say, hey, first of all, I have to have a suppression hearing now. And second, as a result of this, I need to go find these three witnesses, then it may be that that third week of trial is too soon. I hope not, just because this case has been sitting around for a little bit, but you will be in a position to push back because you are getting that discovery later.
So my understanding is the third week of trial is December
12.
Okay, and I just want to be clear, I have a leave that starts on the 16th, and I have international airfare that day.
Okay.
So
then that would be a tricky time to try the case if it's going to be a trial. And it may be as things gel, we try to put this on the week of the 5th. Because that does not run into your international travel. That's still almost a month for the state to track these things down. If the lineup is what I'm remembering and it was shown to someone who basically knows the people involved, not particularly controversial. If the body cam, you have to see what it is.
I'm not terribly worried about the lineup or the body cam. It's the phone stuff that concerns me, because that could change my trial strategy significantly.
Sure. Okay.
It's just phone records. Again, I'm not worried. I'm ready for trial. If
Great.
there's a phone dump that I have.
You may have more you need to work through. But we're clear, it sounds like it's not your client's phone, it's Ms. Castillo's phone, as best you're understanding the review of discovery.
Yeah, it still just affects our trial strategy.
Yep, okay.
So do you want us to report back here on December 5th?
Probably so, but you'll get an email. I have to digest all of the announcements I'm getting today to figure out how all that's going to look. But you will get an email that will show Mr. Cano's case, and it's going to be the 5th and not the 12th. It's just a question of how far down that list is, and we'll see what happens. Okay. All right. Mr. Richardson, anything else on behalf of Ms. Castillo?
No, Judge, I guess I echo what Mr. App said. Mr. Hand, I guess I should be talking to Mr. Whitenhour then, indicated there was some discovery forthcoming. And so I'll just kind of wait and see what it is and then address it accordingly.
Exactly. And the same applies to you. If the discovery you get is, for me to meaningfully process this, I need to hire an expert, or it was 500 gigabytes of data from a phone, and the state's not highlighting the parts it's going to use, then we may need to revisit deadlines. But if it is information that's consistent with what you already have, or it's extraneous, then I'm going to assume we can still be ready to tackle this case the week of December 5. Okay?
Yes, Judge.
And just to, I'm sure the state's aware of this, but just to make the court aware as well, my understanding is the victim is in a state prison somewhere in the state of Georgia and probably Purdue.
He's actually in federal custody, Judge, under an 11-year sentence for weapons trafficking and something else, as I understand it.
Good luck getting it.
All right. Well, we may be repeating poor Mr. Carr's scenario, but we'll see. I trust the state will be working with Ms. Nelson on that, and we'll see what we can do. All right. If there's nothing else, then Ms. Castillo, you are free to go. Mr. Richardson, you as well.
Thank you, Judge.
Excuse me, Josh, can I ask you something?
Yes, ma'am.
I don't mind being an income monitor, but right now I'm not financially stable to pay the income monitor. Is there any way that I can have some type of assistance to pay the income monitor?
Yep. Why don't you and Mr. Richardson should talk after you drop off this call, talk to each other on the phone. He knows exactly what kind of motion to file that will keep the ankle monitor on you, but shift the financing for it away from you, given what you just went through, to the county. Okay?
Thank you.
I'll
Thank you.
follow
Have a
that
good
today,
day.
Judge.
And Ricky, I'm gonna call you later today.
Yes, sir. That's fine.
Yeah, he's in the white t-shirt in the back. All right. Bye.
All right.
Thank you.
You're welcome. Good luck with everything.
Thank you. Thank you.
Have excuse.
You may.
Thank you.
So Mr. Whitenhour and Mr. Hand, this has been moved to the week of the 5th rather than the 12th. So if you could just hop on that discovery issue, we may be able to keep it in the queue. We'll see. My understanding is Mr. Williams arrived. If he could just, maybe Ms. Feely was talking to him, he could just like be in the doorway for a second so Mr. Abate and I could see him. All right, Mr. Porter is back.
Good morning, Judge. This is Attorney Butterfield. How are you, sir?
I'm well. How are you?
I'm good, Judge. I sent a conflict letter in. I'm here in Monroe County down here in Forsyth. Can I have a time to come back on your Zoom on Delon Lomas? I'm about to take a plea, but is there a time certain I could come back to make my announcement on that matter, Judge?
Sure. You could make it right now, or you could come back when you're done.
No, that's fine. Judge, on Mr. Loomis, the court granted our motion for us to do a psych on that matter. And so that's pending. The price went up a little bit, so the family needed a little bit more time. I'm asking that matter go to your January calendar. I understand Mr. Loomis has been incarcerated for some time, but the offer on this case was like a 12-year offer. They reduced it to 7 and they took it back to 12. But we expect that with that psych, we're trying to use that in mitigation. It is going to be a plea, but we are asking because so much time is on the table that we can't be able to have that psych, so we can try to meet with the DA in this matter.
So that sounds reasonable. I want to make sure I understood one thing you said in the middle there. So you said the price went up, meaning your price because the case got more complicated, because
No,
the psych
sir.
eval should
the
cost
psych eval-
$0.
No, this is private psych eval, Judge.
Okay.
Yes, private psych eval, yes, sir.
Got it.
Yeah, the eval, yes, it's a private.
Got it. This is, as you said, then it's entirely in mitigation. It's not an evaluation that you expect will say Mr. Loomis is not competent. It's going to help educate me and the state as to what might be going on in Mr. Loomis's life that could help explain, not justify, but explain some of these allegations.
That is correct, Judge. This is a guy who's never been in trouble, was working a job, and for whatever reason on this incident day, some catastrophic events occurred, as a result of his actions.
Okay.
And then, yes, sir.
So that evaluation has not happened yet because the expert has not been paid, or
That's
it's
correct,
happened?
No, the experts all lined up, but I just talked to his dad this morning. He may be on this call, but he said that he expects at the end of the month, he will have all of the funds to do that. And evaluate is local, and he goes to the jails for me. So getting him in, the court's already granted the order. That's what we needed the court order for, to allow him to go into the jail to conduct the eval. So it's just a matter of just giving him the rest
Mr.
of the
Bate. There's Mr. Williams. All right, you're good. Go get healthy. We'll see you soon. Sorry, we had one defendant poke his head into the courtroom. Mr. Hand, anything you want to add in connection with the Loomis situation?
No, Judge, the state is ready.
Is it accurate that it was 12/7/12?
It was, Judge.
Okay, that's fine. You're free to do whatever. I just a little ping pongy to me, but that's all right. So the request is to move this to our January calendar, which we do have. And you're pretty confident, Mr. Butterfield, that by then the evaluation will be in place, and then it may be a non-negotiated plea, but at least you'll have the tools you need to make in a full-throated way the argument you want to make for a lower sentence than maybe what the state will be asking for.
That is correct. And it's I'm optimistic, Judge. I'm hopefully I can convince Mr. Hand to go back to under that 7, but we'll talk. But that's what I need, the mitigation.
You never know. All right. Well, as long as you are mindful, I'm sure you are, but in particular, Mr. Loomis's family is, the guy's been in jail for over 500 days.
Yes, Your Honor.
So getting closure is important, and a trial is one way to do that. But I'm hearing you say very clearly, trial is not in your client's best interest. This is really not a what happened case. It's why did it happen? And you want to help articulate why things went off the rails so severely for Mr. Loomis that day.
That is correct, Your Honor.
Okay, back to Monroe County or whatever you're doing. And let me add this. Yes, we'll move it to the January calendar. There's no need for you to wait on that if you are able to get all the information you need and make the arguments you need. We can bring Mr. Loomis over anytime that works with your schedule and Mr. Hand's. And so what I don't want us to do is, you know what, we'll just wait till that next calendar is called. If you get that evaluation and it says the helpful things you hope it will, then let's come on in and do the plea.
Thank you very much, Your Honor. Judge, that's going to complete my business with the court. May I be excused, sir?
Yes, sir.
Thank you, Your Honor.
All right, a little bit out of order there. Justin Jones is on the screen.
Good morning, Your Honor.
Good morning, Ms. Primovic.
Mr. Jones is mine, Your Honor. He got a brand new spanking great job in Las Vegas last week.
Oh.
We had an offer of a felony, which he declined. And this morning, we've been given a very good offer that I've been texting Mr. Jones with that we may take this morning. I just need to get on the phone and talk to him and not text with him.
Okay.
So we may be able to take care of this case this morning.
Great. Mr. Jones, are you out in Nevada now?
Yes, Your Honor.
So it's early for you. Ms. Primovic is going to call you. Does she have a good phone number for you?
She does. I actually just texted her several minutes ago.
Okay, well, she's going to call you. You are free to drop off the Zoom for right now and have a conversation with Ms. Primovic. If you are sorting your case out today, you'll need to patch back in so we can have that conversation on the record. So I will need to see you again, either because you're saying no thank you to the state's offer, which is fine, that's your right. But you need to know the conversation we were going to have is the state has announced it's ready to move forward with your case to trial the week of the 28th, which is right after Thanksgiving. So you'll just need to factor all that in as you're weighing things, because you would need to come from Nevada back to Georgia for that trial. But why don't you sign off and await a call from Ms. Primovic. Is this your only case, Ms. Primovic? So she's going to call you right away. I'm going to keep working through the calendar, but she'll call you now. You all can talk, and then Ms. Primovic will come back in, let me know what's going to happen, okay?
Yes, Your Honor, I appreciate it. And thank you to you. Thank you to Marilyn, and thank you, Mr. Hand.
Well, there you go. Thank you, America. We'll see you in a little bit, okay?
Yes, Your Honor. Thank you
All
very
right.
much.
Bye.
Bye.
Melito Perez Vasquez.
Good morning, Your Honor. I'm here on behalf of Jerome Lee.
Hey, that's right. You're always on in house. Does Jerome Lee exist?
He's probably still state judge.
Okay.
He does exist, actually.
All right. It's always Bennett instead of Lee.
I'm the bench.
You are. You do the heavy lifting. So Ms. Perez Vasquez is here. Mr. Shapiro is on trial, and let me find the magic words he shared. There were some motions. There was a motions hearing, but it was canceled because neither motion really needed a hearing. They were things that could be sorted out. And Mr. Shapiro says he's ready when reached. I had talked to the prosecutors in general about what their schedules were, and he had said he could do that week right after Thanksgiving. What's the defense announcement?
We could as well. I'm still hoping we can resolve this short of trial.
Sure.
So I'll reach out to Mr. Shapiro. Our announcement is ready for that first trial week.
Great.
I'll reach out to Mr. Shapiro about possibly bringing this case in earlier than that for a plea.
Excellent. Okay. And does Ms. Perez Vasquez need an interpreter if we're going forward?
Yes, certainly. Perhaps she does. I think that the alleged victim is an English speaker, so we wouldn't need 2 interpreters. But
Okay. All right. So we should have an interpreter here for a plea or for a trial?
either one.
Either one. Got it. Are you able to communicate with her to let her know what we just talked about? Great. Fantastic. Mr. Hand, anything you want to add on behalf of Mr. Shapiro?
No, Judge.
Okay. Then it'll be on the email that I send out listed as one of the cases that I expect to be ready for the 28th of November. But I'm hearing you clearly that you're hopeful that you and Mr. Shapiro can sort it out short of that. All right. Thanks for being here. You and your client are free to go.
Thank you, sir.
So this is, I'm just looking at the booking number. This is 4-year-old conduct, alleged conduct.
It is.
Okay. Hopefully it is work outable.
I hope so.
All right. Mr. Barron entered a plea. Thank you, Ms. Wood and Mr. Whitenauer. Farard Fallen. There he is. Was a noisy standing up. You okay?
Yeah.
Okay. Let's hear what the announcement is. Ms. Wood.
Judge, this will be a misdemeanor plea today. I would like to sign him up after the call, and I would also request, he has a dialysis appointment today, if we could take it.
First,
Thank
we'll do it unless someone has something even more urgent than dialysis. Mr. Fallen will be our first plea after we get through the calendar, and we're almost through.
Thank you, Judge.
All right. Is that what you understand is going to happen, Mr. Fallen?
Yes.
Good. Okay. Then you take a seat, and when it's time for the plea, if it's easier for you to remain seated, we'll do that. You're going to have to come up to the desk up here, but you don't have to stand through the whole thing if that's going to be difficult. Okay.
Yes, sir.
All right. Zolly Ford. Hey, Mr. Ford.
Judge, if we could also come back to this one, I will be ready, but I do want to speak with him about a resolution.
Sure. So, Mr. Ford, there may be a new offer from the state, or it may be that you and Ms. Wood just haven't been able to speak real recently. She's going to want to talk to you about maybe resolving the case today. If not, I have this down for that second week, December 5th. Still good for you, Mr. Hand
Yes, Judge.
and Ms. Wood.
Yes, Judge.
All right. So we'll see what happens. David McKinnon should be in custody, and that is Mr. Sharp. How are you?
Good morning, Judge. How are you?
I'm well. We'll take care of both. Co-defendant, Mr. Russell. I see Ms. Clark at counsel's table. So I am hopeful that this is one we can reach during this calendar. And in talking with Ms. Clark and Mr. Abate, just about Mr. Russell, not about Mr. McKinnon, we had talked about that second week, the week of December 5th. What's that looking like for you? Okay. There had been some motions filed, but some of them were placeholder motions. And I think the way it shook out is that the three lawyers, two defense attorneys and prosecutor agreed, no, there's not actually a motion to suppress statements. There's something about a gun. I think there's forensics, ballistics about a gun. Oh, and there's a motion in limine, which we can handle before the jury comes in, about whether it needs to come in that Mr. McKinnon was arrested with a gun, which may be a gun that has nothing to do with the shooting that allegedly killed the victim in this case. So that's on my radar as very resolvable. I don't think we need to have a hearing in advance of trial on that. Otherwise, you're good to go.
I am. The only thing I would say is, a lot of this is on video. There's one key witness, who I have not been able to locate. I'm not sure if the state's been able to locate him yet, but I would just
Love to have contact information.
I would love, as soon as there is contact information, I would love to have.
Sure. Ms. Clark, we got to chat last week. How you doing?
Good, Your Honor.
Any update?
Only my motion for reconsideration on the bond or reduction on the bond that I filed on October 25th. And I would love the opportunity for my client to view the video that Mr. Abate has.
Okay, so I'm going to table the bond reduction motion right now to see where we go with the trial. The video we can help make happen, whether, especially if Mr. Russell is Mr. Russell here today? So I don't know if it can happen today. We probably could make it happen. You might want to go away and come back because we're going to take care of a lot of other things. But if we've got Mr. Russell here, how long is the video?
2 minutes. I mean, the part that he wants to show.
Yeah, so let's try to make that happen today where you and he can watch it together, especially if it's that short. That's not a big imposition on the deputies. If it was a 3-hour thing, that's a little more complicated. But if that would be helpful with the conversations you need to have with Mr. Russell, let's make that happen today. Mr. Abate, we had talked about the week of December 5th. Does that still work for the witnesses you're trying to line up?
Yes, Your Honor. I don't see it as a problem at the moment.
Okay. Do you know the witness that Mr. Shart's referring to? I don't mean, do you know him personally, but you know who he's talking about?
Yes.
And is that someone for whom you can provide contact information today or make that person available for Mr. Shart to speak with him?
I can definitely get in contact information before the end of the day. We've located him. We've had a short conversation with him.
Okay. Well, all right. Ask and you shall have. Don't know that the guy will talk to you, but you'll get that data if that's his answer. Who knows? Okay. Anything else we need to be juggling in connection? Because this will be one, just so folks get certainty, that will be higher up the list for that that week of December 5th. You feel like otherwise you're good to go as far as you know right now on behalf of Mr. McKinney? Okay. And Ms. Clark, we'll get the video in front of you and Mr. Russell today. Otherwise, you're good to go.
Yes, sir.
Okay. No brutal issues that are going to pop up at the last minute that you're aware of, Mr. Abate?
No, Your Honor.
Okay. All right. Excellent. Yes, sir. Are you related to this case?
Mr. Goldman.
Oh, did you get contact info from him? Yes, sir. You're free to go. We'll see you soon. All right. So, Mr. Shart, I think you're done unless you want to talk to Mr. McKinnon, who's here.
I am willing to take an opportunity.
So we can make that happen. So I'm almost done with the calendar, and then I think they can start making those kind of connections, and we'll figure out how Mr. Russell can watch the video. Okay.
Thank
Great.
you, Your Honor.
All right. Aaliyah Howard. Hello, Ms. Howard. Your lawyer.
He said he was running late, but I don't know.
Okay. We will see if I will have Ms. Nelson reach out to Mr. Arca. He does need to be here. He or Mr. Howard, they're co-counsel on your case, but one of them needs to be here. They know about this situation. Mr. Hand, have you been in touch with either?
Yes, Judge, Mr. Arca, he said he was running late.
Okay.
But we expected to be able to, Judge.
Okay. So 2 things, Ms. Howard. Mr. Arca is on his way, running late, so he will be here. And 2, he hopefully he's told you this, but he told the prosecutor he thinks that whatever offer the state made is acceptable and that will likely be a plea today.
Yes.
Is that news to you?
Yes, he told me, Wednesday.
Okay, so it's not news to you today.
Yes. No,
Okay,
no, it's not.
excellent. Then we'll wait for Mr. Arca and we'll take care of your case when he's here, all right?
Thank you.
You're welcome. Kenneth Hill has been reset. I don't know if he's got brought over. You don't need to, his attorney can't be here today, so Hill can go back downstairs whenever it's convenient for you all. Rodriguez Sexion.
He's mine, Judge.
He is.
I am ready on this one. However, I am hoping to speak with Mr. Hand after the call.
Okay, he's here. You can. No, meaning Mr. Hand is here, so you can. Mr. Sexion is here, so do talk to him. Should we keep Mr. Sexion up?
Yes, Judge.
All right. If it doesn't sort out today, I had this down as second or third week. Any change in any of that?
No, Judge.
No? Okay, I'll see how full those 2 weeks are. Darian Peters.
Judge, this is one of my cases that I'm working on a program for Mr. Peters. I believe Mr. Hand is okay with that resolution. I just need more time. So I'm wondering if the court would allow for this to move to a different calendar other than a trial calendar.
Probably, because I think there's enough stuff still here. Right now it's third week anyway, so it's over a month away. But I know Ms. Patterson can't just snap her fingers to make something line up. Mr. Hand, assuming there is a sufficiently rigorous program identified, is that way out of line with what you might sort the case out for?
No, Judge.
Okay.
She's right, Judge.
Okay. I didn't think she was, I just wanted
That's my
to,
understanding.
I didn't know if that was her hope or if because of conversations you've had, you've indicated, hey, if it's a legit program, the state might go with that.
And we, the state has, Judge.
Okay. All right. So that's probably not an issue, but let's just see how things shake out.
Thank you, Judge.
Fernando Price is in custody,
Judge, same situation with Mr. Price.
as in program and looking for it and don't have it yet.
Correct.
Okay. They are two different people though.
Yes, Judge.
Okay. Do you need Mr. Peters or Mr. Price to stay up here?
I spoke with both of them last week, so they're good to go.
Okay, so Peters and Price can both go when you guys are ready. Jeremiah Hawk. There he is. Hey, Mr. Hawk.
Judge, we would be ready on this. However, I would like to speak with Mr. Hand after the call, so we can come back to this one.
All right. So sit tight, Mr. Hawk. Your lawyer will talk to you. And I had this for second week as well. That still makes sense?
Yes, Judge.
Okay. And that's it. That is the,
I'm sorry.
that's it for the trial calendar. We have two add-ons. One is Sandra LaSalle, who was brought over for us to do what?
That's a plea, Your Honor.
It's a plea, okay. And then Mr. Porter is back. That's Mr. Shapiro's case. He doesn't need to be here for it, but Mr. Shapiro surprised us all by re-indicting Mr. Porter. Mr. Porter represents himself. We did a Ferretta hearing and he is fully on board with representing himself, but we have to rearrange him and I have to semi-Ferretta him again. It's the same alleged victim. It just, Mr. Shapiro recast the indictment. So I'll need a prosecutor to stick around for whenever we do that today.
I'll be here. Judge.
You're gonna be here. So I'm assuming you'll be here for that. Okay. Well, why don't we do this? We're gonna take was there anyone here who thought they had a case today or a loved one who had a case today and they did not hear that case call? No, everyone's in business. Mr. Whitenauer.
Judge, I just wanted to see if Your Honor would be going back to position 3 to see if the defendant appeared.
Oh, right. What did we do? Yeah, thank you. I did make a list. Ms. Grant.
She's in the hallway. with
She's
a
here.
Small child, yes.
Okay, all right, so I need to see Ms. Grant, and then we just need to sort out, she just come in the doorway. Hey, Ms. Grant, how you doing? What's your child's name? Carter? Hi, Carter. How's Carter doing? Good. How old is Carter? 3 months tomorrow. Well, happy 3-month birthday. How'd you get down here? You drove. Okay. So you and Carter are mobile enough that you could make it down here. Okay. We're trying to figure out when to put your case on trial. I know you were here maybe a month or so ago with a visiting judge, and Carter, of course, was even smaller. And that made it kind of tricky for you to be focused on the trial. What is your thought about when you'd be in a position to work closely with Ms. Feely? And we can take breaks during the day, so that I don't know if Carter would be here or with a relative, but if Carter needed to be here, but someone was watching Carter, someone other than you, but you needed to feed Carter from time to time, we can always take breaks like that. But it can't be every 20 minutes. It might be there's one in the morning, then there's lunchtime, there's one in the afternoon. When do you think you're going to be in a position that Carter is stable enough with someone else watching him and caring for him that for a few days you could be with Miss Feely here?
The reason why I have to bring him is because I'm choosing not to vaccinate him. And so, like, a lot of the daycares, even with the exemption for religious reasons, they don't feel comfortable because he's so young.
Sure. Do you have family who takes care of him if you need to take a break?
Yeah, my dad, he's in New York, but when I call him, he'll come down, go to Alabama, whatever.
Okay, so if we figured out a date to have your trial, you think your dad could come down from New York and help out with Carter? Would he, would Carter be able to stay with your dad? You're like in Rome or somewhere. Okay, so if you had to drive down here each morning and we're here from kind of 9 to 5, would Carter be okay with your dad during that window, or does he not? I don't know his feeding situation. I just want to make sure your dad wouldn't, after 3 hours, be saying, "Hey, you got to come back."
No, I do nurse, but I have a stash.
You have a stash, okay, and you're growing the stash. Okay, all right, Ms. Feely, why don't you talk with Ms. Grant about what makes the most sense? It may not be this calendar. That's not why I'm pressing Ms. Grant. It's just very helpful for me to hear. It does sound like she has in mind a support system that would let her be here with you for a few days, going home each night, of course, such that Carter wouldn't need to be here. But we'd need to have that pretty clearly planned so that Grandpa could be here for Carter, knowing, hey, it's not just maybe it'll be tomorrow. It would be, hey, this week you need to be in Georgia and not in New York.
And the other issue is I would need a time frame of when the rest of the discovery might get to me.
What is still not provided in this case?
The discovery was served a long time ago on defense counsel.
Different defense counsel?
Yes.
Okay.
It has been served.
All right.
And when I was made aware that that there was a belief that not all that was present in the defense file, I had my legal assistant work to digitize all the evidence that we had and to then upload it to evidence.com. I've not yet had an opportunity to review all of those uploads to make sure that there's nothing that should not be provided and also that everything is present. I will try to do that today so that that link can be sent to defense counsel and then be reviewed. I'd also note that the offer that was previously extended is now withdrawn.
Okay. All that's noted. Ms. Feely, is what you haven't seen yet something? I know you don't know it because you haven't seen it yet, but I don't know what, it's not your fault, but it is your office. There were several lawyers who said, I have everything and I'm ready, but we didn't reach Ms. Grant's case because she posted bond and that took the pressure off of, oh my gosh, she's been in jail for a long time. Do you have nothing, or you know that what you're missing is, I'm making it up, but a confession, and of course you'd want to read that.
I have the evidence.com link pulled up here. I do have videos of Ms. Grant's statement. They're very glitchy, however, but I have reviewed them with her. And there are some GBI type reports, death certificate. But in terms of like police reports, Mr. Whitenauer has repeatedly referenced jail calls. I don't have any of that.
Okay.
And it just seems like from the state's offer and what I have, I must be missing.
There's a
something.
gap.
Right.
Got it. Okay. I'm familiar with the case just because I and prosecutors and defense attorneys have talked about it so many times because it's been on so many calendars. So I feel like I sort of know what the corpus of evidence would be, but it sounds like Mr. Whitenauer is going to push to get you the things you don't have through evidence.com. And I know this is one of the last carryovers from before, but your predecessors didn't say we don't have police reports. So at one point they were provided and they must just not have made it into your hands. Please talk with Ms. Grant about when we might do this. I don't know that what you don't have in discovery is, it's not going to lead to substantive motions because we would have had those already, I suspect, given that your predecessors were good defense attorneys as well. But we do need to maybe figure out a week that we can say, this is when we'll do this case so that Ms. Grant can plan to have her father come down to take care of Carter. All right. So chat with Ms. Grant. Once you've spoken with Ms. Feely, you and Carter are free to go. Okay. Appreciate you coming down. All right. So why don't we, I know Ms. Wood, you wanted to sign Mr. Fallen up so we could get him to his dialysis. So why don't we get him signed up and then we can start doing some of these, please. All right.
Yes.
You want me to approach?
Yes, sir.
That's what we should start. That's what we should start. 35.
You can. You want to say? Yeah, doesn't matter.
Looks good to me. We'll get an e-file.
Thank you, Judge.
You bet.
Yeah, that completes our business for the court. May we both be excused myself and my client?
Yes, but let me just reflect on what we discussed. Is that what we had said? There he is. Yeah. Okay. Yeah, I don't know how back-uppy it would be. I guess it would be back-uppy to the murder. But we'll see. But yeah, the week of the 5th, and you and Mr. Hand will keep talking. Sounds good. All right, you're free to go.
Sit here and mess with email, or if I go away.
Once he's signed up, yeah, I don't know that he would, she needed to talk to him a little bit, but you just let me know. I'll come right back out when she says they're ready.
Hey, what's up?
When I got your car.
No, just Russell needs to watch the video, not McKinnon. Ms. Clark represents Mr. Russell, and if he can see that video, then that's what you needed to share with him. Yeah, that's all they need to do.
Yes.
She's seen both.
Yeah.
I said certainly. You want me to share Mr. Hand as well?
I'll tell him about it.
Okay. All right, very good.
And I'll send it.
guess I'll send a copy to.
I'll give you my card. Okay.
You're prosecuting.
Look, I pulled them up, I was like, hold on, but no, but I thought it was weird too.
All right, sounds good. Thank you.
Okay. And even up until Friday. Yeah, yeah, I mean, the one that.
You know, we had a hack, so I had to send out a motion.
Well then, yeah, I mean, let me make sure I get your updated one. Do you have her?
I don't.
I gave you mine.
Yeah, that's what I said. But as soon as that Cruz got leaving, now that's the email, letting me know that, hey, this is the email. So check my email. It's a different email, put it in.
I'm gonna tell you it's gonna be a different email.
Put it in Outlook.
Yeah.
That one was hacked.
Yeah,
So we filed the motion and it's just updated.
Yeah, so it's this one right here.
Yeah, so I wasn't getting any of that.
See, and that's the one I got from.
Okay. Was that something I can
From my mom.
Oh, thank you.
I've been writing her letters.
Well, that was my most recent one. So the early one, this isn't her most recent, but that's, see, I replied to this one. She wrote on 19th.
So I wasn't getting
But
any.
she also wrote you on the 7th of September. She was just saying, hey, I'm reassigned to victim special victim unit, students, in-person copy here. And that's the email that I used. That's the one she.
This is Nigerian hacker response here.
Oh, no, we didn't get any.
Okay, so it's a definitely.
No, okay, so I mean, now I have your email. What's your-
That's your email, so they can.
Okay.
I can see that.
Yeah, that way I just have it. What is it?
Bruce, CREWS. And.
.com.
Yeah.
Oh, cruise.legal? Really? All right then.
And, where did this? Over there.
You say right there. To try the chance.
Okay, gotcha.
Clearly couldn't get. Got here.
Go ahead.
I'm working with a very aggressive. It's all.
Yeah.
It's crazy. But with Mr. Carter, let me just, with Miss Charles, we left off, it was kind of over.
Okay.
So our last discussion I had, we were gonna do a phone. We're trying to figure out what we're doing. I know she told me that she could, and I don't know if you guys, she said she couldn't get out to the jails like some order.
Right.
That they couldn't get you to the jail. She said she wanted to talk to Mr. Owens.
Yep.
But she hadn't at the time.
That's right. She had. And she's right. We can now.
Okay.
Yeah.
The prior offer, which had this all, that I was trying to, get us something a little better from Ms. Charles. She said she was looking to our last conversation. It was 3 years of probation. I think
For this one?
The car, right. And I should have- It was a 10-year sentence.
Okay.
Not 3 years. Yeah, it was a 10-year sentence, 3 years of service, excuse me.
Okay.
Okay. And the remaining time.
Okay. Yeah, I was gonna say, I don't know.
What we're trying to do with Ms. Charles, at least see, it's just the best. That's what I wanted to trade probation off. She told me I might not have, and I respect that. But she said she would see, and I think the question she had was let her check and see if the offer from Ms. Hall had expired. The offer from Ms. Hall had expired. She would look to redo a new offer. But that was the last conversation I had with her. I could never get back in touch with her. Obviously.
Yeah. Okay, then let me continue that path, right, and figure out what Ms. Hall was, or if that hasn't expired. From my discussions with her, she definitely seemed north of that amount.
North of what?
Or of the 3.
She's
From my discussion. So from my discussion, I didn't know about Ms. Hall's previous.
Yeah, just curious.
we were just talking about what it would be.
Okay.
And so I hadn't had a chance to check with her to see if she had sent me the final.
She had
anything
not.
before she was transferred. Okay.
Unless you have, it, it's.
Yeah, I don't, I mean, all I have is the one that she sent, the email she sent to you and that I copied after when she said, hey, I'm transitioning, here's evidence. Let me check back with her, just to make sure there's anything hanging out there. Maybe she did send something and didn't get to you, or maybe it got somewhere else. But right now, I'll check.
This is so next time we're going to do a trial.
So we're just gonna.
And I'm trying to without.
Where do you
going
go?
to merge and anything of that nature, just-
Here we go.
Some of the merge, so the offer on the table, I'll work. But I just don't want to come back and forth.
You got it?
You know,
Here, I'll
yeah,
have it to
it's
make
all
sure.
right, let's try to do it, you know what I'm saying?
Yeah.
Because it's not.
There you go. Gotcha.
Gotcha. Okay. No, I mean, and look, if we
Peter's on.
can find a middle ground,
Yes.
we're trying to find it. We're not, you know.
Thank you.
pushing
So just hang tight, when Jess gets back out here,
But I'm here for
please, if you go to your appointment, okay?
And, you know, I did count, it was on a jury trial 3 times so far, and so, you know, going back to 2021. And so, but I think we can work on it.
When can
Sorry.
what would be a time for us to talk?
Let me, I had one more conversation. He's being brought over Thursday. Of course. We try to reconnect Friday. I just wanted to talk to him one more time.
I know, I just did.
We don't talk with him by phone.
It's different.
I can come back.
100% adamant.
Careful, man.
Yeah, did you see the roll on photo lineup?
I did. I'm sitting there
He
talking.
is very convicted.
I'm happy it was glass right there, probably.
Yeah.
But,
Well, I hope my experience was.
yeah, but
It has been so far.
he is fire.
Yeah.
He's fire. Ooh, it was a lot. Sitting in the so I can see it's not gonna be anything other than, hey, my client, she borrowed someone that did it. About it.
Yeah.
Testify.
Okay, and that's consistent to what he said, you know, but also, you know, we'll talk to him because, you know, while he's convicted, right? I need other folks to feel it. We've been able to locate Kayla.
She, from what I understand, she never said that she saw the, no, she saw the drug release. Her initial statement, I didn't see anything, like a woman in the car. Now she's actually saying she saw the shooting, so I don't know if they called it.
Well, I mean, some folks, I mean, if you remember, when they got to the scene, she wanted to just leave.
Sure.
That was her motive at the time, to get away, so.
There's
I think it's
phone call that too, afterwards, with the detective family. Yeah, and she was like, yeah, I didn't see anything. I'm trying to save myself. That's not cool.
Right. You're paraphrasing now.
But you say next Friday, follow.
So this Friday or?
Oh, this Friday?
Yeah, I'm seeing him Thursday.
Okay, so I should show you my first. I just want to know.
No, you're. Oh, yeah, I mean, we probably should mute that thing. Okay.
So, okay, so I reached out to you Friday, but if it's.
I'll check on that call.
If it's the 3, if it's the 10, serve 3.
I got some good.
How are you doing? I'm good. I'm always happy to see you.
Okay.
So just let me know. Check with Friday. Just to call or call you.
Yeah, email's good. I do check it, but.
Yeah. It works still?
Yeah, it's on my phone. Yeah. It's on my phone. 216-223. Nice to meet you. Yeah, I know. I wasn't sure if I was gonna meet you or not. I've heard the name on multiple calendars, so
Have you?
Yeah. Well, just in discussion with the judge about, is this gonna go over real or not?
Oh, with Mr. Carter.
And I'm like, yeah, it's going.
All right.
He's really good at the same thing.
Cool.
All right, we'll reconnect.
All right, that's what
What's that? She was under the impression that her 2006 aggravated assault was sealed. Is that what you showed? But she was not aware she became a felon at this point. Yeah.
just terrible time.
Who's the judge to sign? Like the judge to sign the order to the site?
I'm not sure who's
So they put it under the criminal damage. They did not attach it to the aggravated assault. That makes, oh, wait, no, that's not true. Okay, yeah, it is. Let's see, 2021.
She's done a pretty good time. All what it is, but she remain not convicted felon.
She showed one case for her too, because I didn't get the add-on calendar.
Yeah.
Oh, that's important. Okay.
She's not
So
anything like
let her
that.
know that he's on first cornerstone of October 10th.
And she's gonna be going into
Where is she? Yeah, I was gonna ask, is she housed?
Yes. She just needs to get away from Atlanta.
Okay.
And so I've been in touch with both her mom and her mom's boyfriend who's been in their life, and they're coming up to Atlanta to get her. I told them to wait until I call them and let them know they came through, because by the time, if they leave at the time of plea, by the time they get up here, she probably isn't gonna be kicked out yet. But they're gonna come get her and take her down to Delray.
So that polling is on, is it one or one? And
You
three?
you can get.
Oh, it's one,
Okay,
yeah,
that's right.
yeah, that's
Okay, no, I saw the video, it is, so she was like, oh. Okay, I guess we propose what, disorderly as a replacement?
Yeah.
For that one? Okay.
Perfect. Thank you.
Yes, correct.
Thank you so much.
You're welcome.
This is hilarious.
You're welcome. We're just waiting on the judge to get back on the bench.
Wait, oh my God.
It's delivered over again. This is kind of process of not be. She's not gonna be out.
How long is this recess? There's no time.
Yeah.
No.
Yeah. My gosh, I think maybe good. You can never go wrong with it.
Oh my God.
This is, I mean, like. Fantastic, like usually we have this is. Yeah. I don't know.
Yeah, I'm gonna even talk. No, I just have to tell him quickly, but after that, I'll come by, okay?
He's coming back, he might be. I think he stepped out to the right. To the right, and go that way. We know everything. Where is? Here. I do. Now it's suspended or not suspended. I'm not suspended. Yeah, stay out of doing that. So we're in. You ready, Jake? Keep a job. Yeah.
I emailed him.
Oh, yeah, okay.
Huh? So you come out?
You should come. You're gonna go. Something like that.
Rain, you can let the judge know he's very, what, please.
What,
please?
She said she emailed. There's nothing on it. Walk on the water, remain seated.
Mr. Cruz, what did you and is Mr. Hand around? We need Mr. Hand. We need him because we're also about to take some pleas.
Would you like me to wait for Mr. Hand?
I would, because you and he weren't reading from the same hymnal this morning. So I just want to make sure he has a chance to say, wait, well, that's not what I have to say. Because you sing from the same hymnal. Either way, it wasn't the same one. And then we're ready to go with Mr. Fallon, looks like. There's Mr. Hand. Mr. Hand, two things. First, Mr. Carr and Mr. Cruz, are we now a little more on the same page?
We are, Judge. We've had an opportunity to speak.
Okay.
The state remains ready, Judge, and we'll just continue discussing.
Discussions will continue apace. All right, Mr. Cruz, your announcement?
I would ask for a continuance, but I do understand the court denied it. So at this time, until we receive a final offer from the state, I would just say not ready. But Mr. Hand did explain that by Friday, we should have a final offer on this case, so I can know.
Got it.
Or my client can know,
what exactly his choices are.
Yes, sir.
Fair enough. Okay, good. You'll get an email from me that shows where Mr. Carr's case is on those various weeks, and you'll know what you need to do.
Yes, sir.
Good seeing you.
Thank
you
you.
And he are excused.
Yes, sir. Thank you.
You bet. All right. I think we're going to do Mr. Fallon's plea now. Are you ready for that, Mr. Hand?
Yes.
Ms. Wood, are you ready?
Ready, Judge.
Great. Then let's get on the record.
Here's your victim's Instagram, if you would like to review those.
This one from your.
Mr. Fallon, is it easier for you to handle this seated there than standing up at the podium?
Yes.
That's what we'll do. You just need to make sure you speak loudly so the court reporter can hear you, okay?
Yes.
Great. You can stay seated. Just project. This is position 19 on our trial calendar, State versus Farard Fallen, 22 SC 181-900. My understanding is that you're ready to enter a plea. For that to happen, you'll need to be put under oath. Once you're under oath, Mr. Fallen, you'll need to answer all of Mr. Hand's questions and my questions truthfully. If you have any questions of your own at any time, let Ms. Wood know so that she or I can try to answer your question, okay?
Yes.
All right, when you're ready, Mr. Hand.
Yes, Judge. Yes, Judge.
Did we move too quickly for you?
Yes, I was hoping that it would take a slightly longer, Judge, but your intro has come really succinct.
Well, I have to do it a bunch of times today, so I'm trying to shrink it.
All right, Judge. I'm ready.
All right.
All right.
Are you reducing or dismissing any charges?
I am, Judge. So count 1 and count 2 will both be reduced to 2 counts of disorderly conduct, Judge.
All right.
All right, Mr. Fallon, if you could for me, raise your right hand so we can see it in the camera. Is able to, oh, okay. Do you swear or affirm that the statements that you shall give today shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Please state your true and correct name for the court.
Farrar Fallen.
And Mr. Fallon, are you at this time taking or under the influence of any drugs, medication, or alcohol?
No drugs.
Okay. Are you
How
taking?
about medicine?
I take my blood pressure medication. I got to.
Does the blood pressure medicine make you woozy or confused or dizzy at all?
No.
Okay. And how about alcohol? Any alcohol today?
No.
Okay, great. So you feel like you're understanding what we're talking about?
Yes.
Great.
And Judge, may I reposition myself? I don't want Mr. Fallon to keep turning. And
You may position yourself wherever you want to be.
thank you, Judge. All right, Mr. Fallon, how old are you?
41.
And how far have you gone in school?
GED.
Can you read, write, and understand the English language?
Yes.
And do you understand that you have been charged, and these are not the final charges you will plead to, but you've been charged with 1 count of aggravated assault with a deadly weapon, and then aggravated assault, family violence?
Yes.
Okay, and that's in indictment 22 SC 181-900. Do you understand that you have the right to plead guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes.
Have you had an opportunity to review all of your rights with your attorney?
Yes.
Do you need more time to speak with your lawyer about all of the charges in this indictment, including facts and circumstances?
No.
Are you satisfied with your lawyer's services?
Yes.
Attorney Wood, do you waive formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects in the indictment for purposes of today's plea?
So waived.
And Your Honor, the state is unaware of any outstanding warrants related to these charges.
Okay.
Mr. Fallon, do you understand that the minimum and maximum sentence for each charge to which you are pleading guilty are for count 1, 1 to 20 years, and for count 2, 1 to 20 years?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court, that being for count 1, a downgrade to disorderly conduct, and the sentence being 12 months probation and an anger management course, and for count 2, a downgrade also to disorderly conduct and consecutive 12 months probation?
Yes.
So a total of 24 months probation.
Yes, Judge. Is that your understanding, Mr. Fallon?
Yes.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty today, which there are 2, the court also has the right to run those consecutively, which means one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you're currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation, which is the recommendation today, you cannot violate any criminal laws of any governmental unit, those being municipal, county, state, or federal?
Yes.
Do you understand that if you are on probation or placed on probation, you must follow all of the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all of these special conditions, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess, use a firearm while you're on probation?
Yes.
Are you a United States citizen, Mr. Fallon?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, which include any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those are a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if you're convicted of these charges at a jury trial.
Yes.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of count 1, disorderly conduct, count 2, disorderly conduct, and indictment 22 SC 181-900?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, that you have a limited right to challenge it by filing a document called a habeas corpus petition?
Yes.
Do you understand that for a misdemeanor, you only have 12 months from today to file this habeas corpus petition?
Yes.
Okay. And Judge, at this time, the state will give a factual basis for the trial. Judge, the state, if this were to go to trial, would prove beyond reasonable doubt on October 29th, 2020, APD officer McIntyre responded to a fight call at 421 Boulevard Northeast involving a weapon. Upon arrival, he met with Carrie Fallon, who informed her that her adult son, Carrie Fallon is the mother of both the defendant and the victim. She stated that her adult son had been in a verbal dispute with the daughter, whose name is Tamika Fallon, over a television. Mr. Fallon was staying with her at the time. Ms. Fallon also lived close by and she was just over, but she's not staying at the residence then or currently. The argument escalated and became violent. Mr. Fallon explained as well to the officer that Tamika threw something at him, a water bottle, but then he went into the kitchen from the family room and retrieved a knife. He brandished the knife, approached his sister with it. The mother, Mrs. Fallon stepped in between them to break them up. He yelled, "Get out of the way." Ms. Fallon was nearly cut. As she felt that she would have been if she hadn't moved out of the way. Mr. Fallon swung at Ms. Fallon as well, trying to hit her during this altercation.
When you say Ms. Fallon, his sister or his mother he swung at?
The sister, Judge.
Okay.
Tamika Fallon. I should use first names.
Or sister and mother, either way.
He swung at the sister, Ms. Tamika Fallon.
Both?
Yes. He also made the statement, if she comes around me again, I'm gonna do it. I don't mind going back to prison. The knife itself, when the officer arrived, was not recovered, Judge. We're not sure what happened to it, but both witnesses, the mother and sister, stated that consistently that there was a knife involved. And that's the total factual basis, Judge.
Excellent. Thank you. Good morning, Ms. Jackson. How are you?
Good morning, Judge. How are you?
I'm well. Can you tell me a little bit about Mr. Follin's criminal history?
He has 4 cycles. The defendant's last arrest was March the 14th, 2006 with the City of Atlanta Police Department for armed robbery, and it was aggravated assault. That aggravated assault was dead docketed. The defendant does have prior felony convictions. There's one in 2007 out of Fulton County for armed robbery, and additional one in 2007 out of DeKalb County for armed robbery, and 2 counts of aggravated assault. Nothing in addition, Your Honor.
Thank you so much. And Ms. Tucson, good morning to you.
Morning.
Is Mr. Follin on probation from either of those old cases?
No, Judge, no probation at the moment.
Thank you. Okay. Ms. Wood.
Thank you, Judge. Mr. Fallon is 41 years old. He lives here in Atlanta with his mother, who is present in court today. Judge, as you heard, he does have his GED, and he is actually disabled. He's blind, and he has kidney failure, high blood pressure, a number of other things going on, Judge. The reason I point that out is because at the time of this incident in 2020, so over 2 years ago, Mr. Fallon, his mother, and a number of other family members were living in a 1-bedroom apartment. So tensions often would rise over limited space, and then coupled with Mr. Fallon's disability, sometimes he would bump into things, there would be words exchanged. It's our understanding from our research on this case that that is what happened in this incident. There was just a little argument over something, and then it turned into something else. We also want to point out that since the knife was never recovered, we don't know if it was a butter knife, could have been a butter knife, Judge. The sister, Tamika, was also arrested on the scene as well for a misdemeanor. So that's why we felt this was appropriate for Mr. Fallon to get a disorderly conduct, Judge. I do want to just reiterate, the sister, Tamika, does not live there now. It's just Mr. Fallon and his mother, as I understand it. So we would ask that you accept this recommendation. The other ask that I would ask of the court is if the court would consider waiving probation fees so that he can put his money towards the anger management course. And then my last request is if Mr. Fallon is doing well, if the court would consider suspending the sentence after the first 12 months.
Sure. I didn't remember, and maybe I didn't write it down, that anger management was a condition.
I omitted that, Judge. My apologies.
Okay.
There's a request for an anger management course specifically because Tamika Fallon has mentioned that she just wants him to get help. She doesn't want no further contact because it's a brother.
Sure.
But no further.
And they don't live in the same place anymore. So, Ms. Wood, Mr. Fallon, your client is still at the 421 Boulevard, the small space, but now it is your client and his mother. It's less congested.
Correct, Judge. Miss Tamika lives with her daughter now.
Okay. And Mother Fallon, which one are you here? There you are. Are you okay that your son is still living with you? Have things gotten a little bit better? Okay, good. Thank you for being there for him. All right. Mr. Fallon, do you have any questions?
No, sir.
Okay. Well, you're dealing with a lot with the kidney situation and your eyesight, but it is important to do your best to keep an even keel. That's not always easy, especially when people are all living on top of each other. But these are family, and everyone cares about everyone else in that group. Mr. Fallon, I find there's a factual basis for your plea. It sounds like that day just before Halloween 2 years ago, tempers got a little hot and you got into it with your sister. Fortunately, your mom was able to break it up before anyone got too injured. I also find that your plea is knowing and voluntary. Voluntary means you're entering this plea because you have decided that's the right way forward for you. No one's forcing you to do it. Is that correct?
Yes.
And knowing just means you've understood everything. And you've told me you don't have any questions. So I assume that means you've understood what we've been talking about. Is that right?
Yes.
Great. Mr. Fallon, I am going to sentence you on count 1, which has been reduced to disorderly conduct, to 12 months on probation. Count 2 will be also reduced to disorderly conduct and will also be 12 months probation. So it's a total of 24 months probation. I will waive your probation supervision fees because it sounds like you're on very limited means and you use a lot of your means to pay for important things like dialysis. You will, however, have to take an anger management course, and you may have to pay for that. It's not going to be $1 million, but it might be more than $0 as well. But that will be a special condition of your probation. That and no violent contact with either your sister, Tamika Fallon, or your mother, Carrie Fallon. So you can be around them, their family, but no pushing or shoving or anything like that. Just respectful conduct. You're welcome to contact. You're welcome to hug your mom, but don't swing a butter knife or a steak knife at her. Do you have any questions about anything I just described?
No, sir.
I'll also recommend that your probation be terminated early if you've taken the anger management course and everything else is going smoothly. If it's all good reports, there's no need for that to keep on going after about 12 months. Misdemeanor probation is going to have to set up an appointment with you. They'll work through Ms. Wood, your lawyer, and she'll reach out to you. But at some point, you'll need to meet with them to get signed up with that program, okay?
Okay.
Mr. Hand, anything else for Mr. Fallon's case?
No, Judge.
Ms. Wood, anything else?
No, Your Honor.
Mr. Fallon, do you authorize my staff to electronically sign the indictment indicating your guilty plea to those 2 counts?
Yes.
Ms. Wood
Yes, Judge.
and Mr. Hand.
Yes, Judge.
Ms. Fallon, any other things you want me to say to your son, or you think he's good to go? He's okay. All right. Mr. Fallon, you go get to your dialysis appointment. And again, misdemeanor probation is going to need to talk with you soon. You got to make that first appointment, because if you don't, then they come to me saying, we can't find this guy, and it gets complicated again. Okay?
Okay.
All right. That's it.
Thank you,
Okay.
Judge.
You're welcome.
Yeah, I'll be here, Judge. Yeah, I'll get your information. Okay.
Ms. Clark, you are still here and you're welcome to stay here. You may be on the PD bus. Is there something I can do to help, or you're all set?
They just took somebody down, they said, so I'm almost finished.
Okay, great. I just want to make sure you were being taken care of. Ms. Feely, do you have something while Ms. Wood is helping Mr. Fallon get out, or should I see what Ms. Wood has next?
Ms. LaSalle's, please, she's on the add-on calendar.
Sure. Are you able to pivot to Ms. LaSalle? Great. Why don't we bring Ms. LaSalle out? Ms. Jackson and Ms. Tucson, do you have that add-on calendar with Ms. LaSalle, or do you need a case number?
I have it, Your Honor. Thank you.
Great.
I
thank
have
you.
it. Thank you.
Great. Will this be to felonies, misdemeanors, just misdemeanors? Okay.
One second, Judge, I'm sorry.
Is it all right if I get us, I know you're not, but can I get us started on the record? Good, okay. Good morning, Ms. LaSalle.
Good morning.
Good to see you again. I'm still Judge McBurney. Ms. Feely tells me you're prepared to enter a plea in your case. It sounds like the charges are being reduced to misdemeanors. You ready for that?
Yes, sir.
Okay. Well, your case is 22 SC 181815, State versus Sandra LaSalle. And in a moment, Mr. Hand is going to swear you in, put you under oath. Once you're under oath, it's important that you answer his questions and mine truthfully and completely. It's also important that if you have any questions because someone says something that doesn't make sense, or it's just not going the way Ms. Feely said it was going to go, that you stop us and you and Ms. Feely can talk about it, or you and I can talk about it. Will you do that?
Yes.
Okay. Mr. Hand, when you're ready.
Yes, Judge. All right. Mr. LaSalle, if you could for me, raise your right hand. Do you swear or affirm that the statements or testimony that you shall give the court today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can lower your hand. Please state your true and correct name for the court.
Sandra LaSalle.
Okay. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, sir.
Is there any medication that you would normally take today that you have not taken or been given?
No, sir.
Okay. How old are you?
35.
And how far did you go in school, Mrs. LaSalle?
I have college education. I have a college education.
Okay. Did you complete college or just some college?
I completed, yes.
Okay. And is it fair to say you can read, write, and understand the English language?
Yes. Yes, I do.
Do you understand that you have been charged with the following offenses today? Those are willful obstruction of a law enforcement officer by use of threats of violence. Count 1, count 2 is simple battery against a police officer. And count 3 is obstruction of law enforcement officer.
Yes.
Okay. And Judge, as stated earlier, these will be misdemeanor pleas. So the first charge, which is the only felony, will be downgraded to disorderly conduct.
So 1 disorderly conduct, 1 simple battery against a police officer, and 1 misdemeanor obstruction of law enforcement officer.
Yes, Judge.
Okay, and that officer is A. Ward.
Yes, Judge.
Okay,
Do you understand that you have the right, Mrs. LaSalle, to plead guilty or not guilty to these charges today?
Yes, sir.
And do you understand that if you plead not guilty or remain silent or not enter a plea at all, that the state is required to prove these charges against you at a jury trial?
Yes.
Have you had an opportunity to review your rights with your attorney today?
Yes.
Have you had enough time to speak with your lawyer about the indictment today, as well as the charges in the indictment?
Yes.
Would you like more time to discuss your case with your lawyer?
Yeah.
Are you satisfied with your lawyer's services?
Yes.
At this time, Attorney Feely, do you waive a formal reading of the indictment for purposes of today's plea?
Yes.
And do you waive any and all defects in the indictment for purposes of today's plea?
Yes.
All right. And Judge, the state is similarly unaware of any warrants related to the charges in this case.
Okay.
Ms. LaSalle, do you understand that the minimum and maximum sentence for each charge to which you're pleading guilty today are each 1 day to 12 months imprisonment?
Yes.
Okay. And do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? That sentence is for count 1, 12 months probation, credit for time served. I believe she spent 90 days in custody, Judge. And
while you're looking that up, Ms. Howard, have you heard anything from any of your lawyers? Okay, good. Was that the gentleman who just walked in? Okay, great.
all right, Judge, I'm sorry, let me restate that. Judge, it would be 90 days time served for count 1. Count 2 would similarly be 90 days served and credit for the time that she served, and same thing for count 3.
Okay,
So essentially a time served sentence, Judge.
understood.
All right. Is that your understanding, Ms. LaSalle?
Yes, sir.
You understand that the court is not required to accept the state's recommended plea today?
Yes, sir.
And do you understand that the court is not required to, can sentence you to the maximum possible sentence on each charge today?
Yes, sir.
Do you understand that if there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively, which means one after the other?
Yes, sir.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you are expecting today, that you have a right to withdraw that plea?
Yes, sir.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
And do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
So is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to enter into a guilty plea?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of disorderly conduct, simple battery against a police officer, and willful obstruction of a law enforcement officer?
I plead guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
And do you understand that you have a limited right to appeal this guilty plea conviction?
Yes. Yes.
Okay. And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
Do you understand that for a misdemeanor charge, which all three are today, you only have 12 months from today to file a habeas corpus petition?
Yes, sir.
Okay. All right. And Judge, the state will provide a factual basis for the plea today as well. Judge, were this proceed to trial, the facts will show that on July 2nd, 2021, Officer Corporal Ward was notified of a small fire.
So I've got a very, very different day of December 14th, 2020. I'm just looking at the indictment. It's not a fatal flaw. It's just real different day.
That is a different day, Judge. 2 seconds here. I just want to check it at the source. That is correct, Judge. December 14th.
Okay.
Okay. December 14th, Corporal A. Ward was notified of a small fire on Mills Place in the roadway. That's 4599 Mills Place. This is in Fulton County. When she approached, she observed a fire and a suspicious woman that she had actually recognized from before, responding to another fire at a different time. The woman at the time made the statement, "It's cold outside," and she was identified at that time as Sandra LaSalle based on her knowledge of her from the previous incident, Judge. She's known apparently for starting fires in the area. At that time, she was detained by Corporal Ward. She began forcefully resisting. She was about to be detained on the ground when she fled from Corporal Ward. She ran behind a building, but before she made it to the building where she hid, she hit Corporal Ward with something that led to an injury to Corporal Ward. She then proceeded after her, found her hiding behind a building on the ground, and then she was detained at that point and taken into custody. She was charged only for the battery and the willful obstruction.
So Corporal Ward is okay, sort of perils of the job, but that's how it played out.
Right.
Okay.
I mean, it didn't sound pleasant looking
No.
at the body cam, but
No.
she is
Okay.
okay.
All right. Good. All right. Ms. Jackson, can you please share criminal history for Ms. LaSalle?
Yes, Your Honor. The defendant has 13 cycles. The defendant's last arrest was November the 1st, 2019, out of Tennessee for aggravated assault. There was no disposition for that arrest listed in the GCIC. The defendant does appear to have an outstanding hold out of Knoxville, Tennessee for a probation violation. The date on that warrant was February the 13th, 2020. The defendant did receive first offender treatment in 2006 out of Douglas County for 2 counts of aggravated assault and 2 counts of criminal damage to property in the first degree. That case was sealed April the 30th, 2020. The defendant does have misdemeanor convictions. There's one in 2018 for disorderly conduct, an additional one in 2018 for obstruction of an officer, and the defendant received a nolo contendere sentence in 2007 for obstruction of an officer. And there was one in 2005 for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, any open probation matters for Ms. LaSalle?
No, Judge. That first offender that was recently discharged.
Okay,
From
got it. Thank you.
No problem.
Ms. Feely, share with me a bit about Ms. LaSalle and help me feel comfortable that Ms. LaSalle is going to be plugging into some resources that might help prevent some of these things from recurring.
Absolutely, Your Honor. So she is 35. This is the one where I've been in close contact with her parents in Delray Beach, Florida, and they've set up, she has to be assessed to see if it will be inpatient or outpatient, but it will be an intensive drug treatment facility. And a big part of that is also just getting away from Fulton Industrial and the influences here, which is why we didn't want her to necessarily have ties here. And they are at the ready, hopefully watching on YouTube to be able to reunite with her. She does have a very supportive family. She just has been not on the right track, but 65 days in jail. She is more than ready to go down and start dealing with some of that.
So the 65 days were the product of the bench warrant, and Ms. LaSalle's basically been in custody nonstop since she was picked up on the bench warrant?
Yes, sure.
So the arrest back in December of 2020, she might have been in for a couple of days, but bonded out.
She was in 27 days.
Oh.
I can put those dates on the record.
So it's 27 plus 65, or the total is 65?
The total is 92.
Total is 92. Okay, got it. Ms. LaSalle, do you have any questions about anything?
No, sir. No, Your Honor.
Ms. Feely, so the help that Ms. LaSalle will get through her family is down in Florida. In other words, Ms. LaSalle would be returning there to get the type of treatment you described?
Exactly. And they're going to come transport her and get all that handled. It's Delray Beach, Florida. And I would also point out, I've also watched the videos, and while we are owning up to the, I guess the elements of the crime, we have a much different picture should this case proceed to trial. But this is obviously the right outcome at this point in Ms. LaSalle's life.
Sure. What happened? Ms. LaSalle will get out in the next couple of days. What happens during that transition between she's released and her parents find her? Where let's just say Thursday morning at 8 a.m., Union City releases Ms. LaSalle. Where is she going?
They are on standby to drive up from Florida today.
Okay. It's that connected that her parents will be there. Sort of like we see in the movie, someone walks through that gate and there's a Buick LeSabre and that's the girlfriend's waiting for you. Okay. Got it. Well, that'll be how it plays out. Ms. LaSalle, this is a great opportunity for you. Not the fact that you've been in jail, but the fact that your parents are going to come get you and try to connect you with help. You are an adult and you're going to have to embrace that treatment that's being made available to you. I hope you choose to do that. It sounds like that will help. You've been through some tough times with addiction and maybe some mental health issues that people want to try to help you with, but you need to invest in the program, because if you don't, you may wind up back on Fulton Industrial where the officers know you by name and you're having to try to light a fire because it's cold out. And I know that's not what you want. I know it's not what you need. So I hope this works out for you. Will you give it a try?
Absolutely.
Good. All right. Well, Ms. LaSalle, I find there's a factual basis for your plea. You and Corporal Ward had some kind of tussle. It sounds like there's maybe more to it than just the narrative I received, but there's enough to it that I'm going to accept your plea. I also find that your plea is knowing and voluntary. Voluntary meaning no one's forcing you to do this, and knowing meaning you understand what we're talking about. Are both those things true?
Yes, Your Honor.
Okay, then I'm accepting your plea. I'm going to sentence you on each of the 3 counts, and that first count's been reduced to disorderly conduct to 3 months to serve. But you'll get credit for all the time you've been in. And Ms. Feely's going to give us those initial dates when you were in, way back in December, January of 2021. And then we know when you've been in most recently, because I got when you got picked up on the bench warrant. But if you add those 2 numbers together, you get a number more than 90, which is 3 months. So you should be released today or tomorrow, which is great.
Yes, sir.
But you need to then go with your folks and try this new approach down in Delray Beach where it's warmer and you won't need to set fires, okay?
Absolutely.
All right, Mr. Hand, anything else for Ms. LaSalle's case?
No, Judge.
Ms. Feely?
Just put in those dates on the
Please.
record. So the incident date, December 14th of 2020 is when she booked in, and she was released January 9th of 2021. And then she's now been in since September 5th of this year.
Great. Ms. LaSalle, do you authorize my staff to electronically sign the indictment indicating your guilty plea?
Yes.
Ms. Feely
Yes, Your Honor.
and Mr. Hand?
Yes, Judge.
Great. Then we are all set and you ought to be back in Florida before the weekend, okay?
All right.
All right. Good luck with everything.
Thank you.
So schedule wise, in a few minutes, this class is going to arrive to observe. We're good until 12:30. I have a case management meeting from 12:30 to 1:30, and then we're back. So if there are pleas we can take, we should keep taking them. If there are more pleas than we have time, we will take the rest of the pleas today. We'll just, folks can get a lunch break, and then we'll come back after that. So I know we've got private counsel here, and if he's ready to go, we could do that. But we may also have the gentleman from Las Vegas back on. So maybe we could try to do both those, but we'll see. You are Mr. Arca?
Correct, Judge. I just got done with Cobb County Superior.
Great. And now you're in Fulton. No Zoom for you today, apparently. All right. So Ms. Howard told us she thinks she's ready to enter a plea. I think Mr. Hand had said it's lined up. Are you ready to do that?
I just need to get paperwork filled out, Judge. Should take me no 5 minutes.
Okay. Well, let me ask Ms. Primovic, are we able to do your client?
I just need to speak with Mr. Hand when he's not taking a plea. We are expecting a plea. The offer was disorderly conduct and he accepted and we were ready to sign up. But then Mr. Hand just said something else to me while he was walking in. So I don't know what way he's going.
Okay.
We're not doing pointing a pistol, but we will do the agreed upon disorderly conduct.
Well, now we're negotiating out in public here. I won't make you respond in public. She's just letting you know. Okay, that's fine. Just, I'll let you focus that at him. Because it was all going this way. So I felt some warmth.
Sorry, Judge.
That's all right. But all the pleas are yours that remain. So why don't we, I'm not worried about the paperwork unless Ms. Howard's going into custody, and I bet she's not. So why don't we do Ms. Howard's plea? Great, come on up.
Judge, you obviously can move forward. I'll just need 1 second.
One thing I can do that will free some things up is maybe we could do Mr. Porter next after this plea. And then you'll be able to talk with folks because you just need to be physically present. My interactions with Mr. Porter,
Okay.
I just need a prosecutor in the room.
Okay.
Yes. Sure, it's Alex, ALEX. Last name is Arca, ARCA. And I'm here today for my partner, Mr. Brian Howard, who you might already have on record.
Let me know when you're ready, Mr. Hand.
And Judge, just to give you a heads up, we're going to be requesting a certificate of first conviction on the DUI.
You're gonna have to explain what that means. I don't see a DUI listed here, but maybe something's being reduced to DUI. We've got felony obstruction that I'm guessing is being reduced, and then simple battery against police officer. But I'm pulling up the indictment right now. Maybe the indictment says something different than the calendar.
Judge, I may need a moment to talk to Mr. Parker to make sure that we're.
Yeah, Judge, sorry, there was no DUI. It was a disorderly conduct. My apologize. My
Okay,
apologies.
yeah. So you still need to talk to him? Okay,
Because that's not my understanding.
okay. Well, why don't you guys talk for a quick second?
All right. Just go ahead and have a seat. Judge, we worked it out.
Well, that was prompt. All right, Ms. Howard, you're back on.
What I meant to say is this please can be done under first offender, Judge.
Okay,
That's what
I thought it might be.
I just got a little confused. I remember we had agreed to the Mothers Against Drunk Driving panel. So that's what threw me off, but
okay,
it's a first offender plea.
We're all good.
All right.
Right, Judge.
Should I start my colloquy or is that too soon?
You can start your call.
He's got it.
All right. Ready, Ms. Rivers? This is position 23 on our trial calendar, State versus Aaliyah Howard, 22 SC 181963. Ms. Howard is here in court with her attorney, Mr. Arca. Mr. Hand's representing the state. And it's my understanding, Ms. Howard, that you're prepared to go forward with a guilty plea. Is that correct?
Correct.
I say guilty plea. It may be first offender, which means it won't be a conviction, but we'll have a conversation about that. Either way, you'll be saying at one point, if you're going forward with it, guilty to whatever charges remain in the case. Mr. Hand will put you under oath in just a minute. You've watched this process now happen a couple times here in court. Once you're under oath, it's important that you answer truthfully all the questions that are posed. And it's just as important that if you have questions of your own, you let Mr. Arca know so that he or I can answer those questions. Will you do that?
Yes, absolutely.
All right, excellent. Well, when Mr. Hand is ready, he will get you under oath.
You may have spoken too soon. I'm sorry.
This is a pattern.
I'm sorry.
That's all right.
He's a good guy. I can vouch for him.
He is juggling about 97 things right now, so everyone's cutting him some slack. Mr. Ford, how you doing? This isn't on the record. I just got an email. Sounds like you don't want to work your case out today. Whatever the offer was is something you're not interested in at that time. Is that correct? Pardon me? That wasn't my question. It just was whether you're going forward with it or not. So let me find your case on the calendar. Make sure I know what you're describing as ridiculous. So you're charged with aggravated assault and aggravated battery. Each of those carries up to 20 years and then one misdemeanor. But today's not the day to work it out. You don't have to work things out. This case will remain on the list for cases that we line up for trial the week of December 5. Ms. Wood will be in touch with you anyway. She knows all this. She's just talking with other clients, and I didn't want you to have to stick around. Saw you frantically eating that bag of chips. So you are free to go. I'll let Ms. Wood know that we spoke, and you should know that if between now and then the ridiculousness doesn't clear up, you'll need to be here on the 5th, this same courtroom, and be ready to go to trial. Okay? Excellent. So I will see you either before then because something's working out, or on that date, so that we can get you some jurors. Okay? All right.
Judge, I'm sorry, I am missing the factual basis for this and I can't.
I can stipulate if that makes it easier.
I mean, as I understand it, now that I'm learning about Mad, Ms. Howard had too much to drink and she got partway put in a squad car and she kicked some officers.
Right.
Nothing,
No.
bad decorum,
I can give
officers
a
are
general
okay.
description. I just don't want to miss anything that you may need exact
Okay,
street names or dates or anything. And I don't.
I got the date, November 22nd, 2020,
All right. Then
and the officers' names. So I think we're good. We'll see. I think we can
work
get our way through this.
Okay. All right, Ms. Howard, if you could for me, raise your right hand. Do you swear or affirm that the statements that you're about to make to the court are the truth, the whole truth, and nothing but the truth? Okay, you can lower your hand. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, sir.
Okay, and is there any medicine that you would normally take that you have not taken today or been given?
No.
All right. How old are you?
27.
And how far have you gone in school?
I just finished my bachelor's.
Okay. And can you read, write, and understand the English language?
Yes.
Okay. Do you understand that you have been charged in today's indictment, which is 22 SC 181963, with 2 counts of willful obstruction of a law enforcement officer by use of threats or violence, and 2 more counts of simple battery against a police officer in today's case? Okay. Do you understand that you have the right to plead guilty or not guilty to these charges?
Correct.
Do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that it's the state's responsibility to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review all of your rights with your attorney?
Yes.
Have you had enough time to speak to your lawyer about the charges in today's indictment, as well as facts and circumstances surrounding those charges?
Yes.
Would you like more time to discuss this with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Okay. Do you waive, for the Attorney Arca, do you waive a formal reading of the indictment for purposes of today's plea?
I do, Mr. Hand.
And do you waive any and all defects in the indictment for purposes of today's plea?
Yes, sir.
Okay. Judge, stays unaware of any warrants outstanding for this charge as well.
Okay.
These charges. Ms. Howard, do you understand that the minimum and maximum sentence for each charge to which you're pleading guilty to today are as follows? For willful obstruction of a law enforcement officer, 1 to 5 years. For the second count of willful obstruction, 1 to 5 years. For simple battery, 12 months. And for the last charge of simple battery, 1 day to 12 months as well.
Yes.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means that the state will make the following recommendation to the court? Because that recommendation is for count 1, 1 year probation, the drug and alcohol treatment and evaluation, or evaluation and treatment. And then the Mothers Against Drunk Driving panel, which Mr. Arca and I discussed as being an evening where she goes and hears from mothers who've had kids injured by or lost kids to drunk driving. Count 2 is 1 year probation as well, but that one would include an anger management course. Count 3 would be 12 months probation, and count 4, 12 months probation.
Are those concurrent, consecutive?
All concurrent, Judge.
So a total of 1 year probation.
Yes.
Correct, Judge.
Okay.
Do you understand that being the recommended sentence?
Yes.
Okay. Do you understand that the court is not required to accept the state's recommended sentence today?
Yes.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge today?
Yes.
Do you understand that if there are multiple charges to which you are pleading guilty today, that the court also has the right to run those consecutively, which means one after the other?
Yes.
Do Do you understand that if the court decides to order a sentence that differs from the negotiated plea, you're expecting that you have a right to withdraw that plea today?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation today, you cannot violate any criminal laws of any governmental unit, that being state, federal, local, or municipal?
Yes.
Do you understand that if you are on probation, you must follow any and all special conditions of that probation?
Yes.
Do you understand that if you fail to follow all of the special conditions of the probation, then you will be subject to revocation of that probation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're entering a plea of guilty today? And because of that, you are waiving any and all defenses, including any mental health defenses that you may have?
Yes.
Okay. Do you understand that by pleading guilty, you are giving up the following rights? Those are a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if you're convicted of these charges at a jury trial.
Yes.
Is it your decision to waive these rights, which means to not use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of willful obstruction of law enforcement officer by use of threats or violence, which is the same charge for count 2, and then for counts 3 and 4, simple battery against a police officer or detention officer?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that if you want to challenge the voluntariness of this guilty plea, you must file a document called a habeas corpus petition?
Yes.
And for a misdemeanor charge, you only have 12 months from today to file this habeas corpus petition?
Yes.
Okay. Your Honor, at this time, the state will give a very general factual basis.
All right.
But accurate. Your Honor, this incident occurred in November 22nd, 2020. Officers arrived to a car accident location. Once they were there, they observed someone who would be later identified as Miss Aaliyah Howard. She was trying to explain to the officers what occurred. Her car had run into, I believe, a bush of some sort and been in an accident. The officers observed that she had slurred speech at the time and asked her for her driver's license. They could not obtain it from her initially, and so they decided to detain her until they could get the driver's license. There were 2 other folks at the scene who I believe to be family members of her. It is unknown whether they were in the car when everything occurred, but they were trying to calm her down because she became upset that 2 Black male officers were participating in the system and arresting another Black female. These were statements that were made. They put her into handcuffs, put her in the back of the car while trying to get her into the back of the car to be detained for questioning. She kicked one of the officers. It was not a severe injury, but she did do harm to the officer. She finally got into the car. They took her to, they finally got her driver's license from a family member, but they took her to, I believe, get some type of treatment to detox at a hospital. Once there, the officer took off the handcuffs so that they were behind her back initially so that they could be in front of her in order for the nurses to assist her. Once they were off, she then resisted putting them back on and pushed the officer at that time as well. She was pushed to the ground, re-handcuffed, and then everything proceeded from there. And she was taken into custody later thereafter.
Okay. Yeah, I found the police report. Sounds like, at least according to the officer's report, Ms. Howard made such a ruckus outside her car that like strangers were coming out of their houses, like, what's this lady up to? So sounds like it was a bit of an event that night. All right. Anything else from the state?
No, Judge.
Ms. Jackson, any criminal history for Ms. Howard?
I see 2 cycles. The defendant's last arrest was August the 26th, 2014, for a failure to appear, and that was in Clark County, Georgia. The underlying charge was not listed, and there was no disposition, no convictions listed, Your Honor.
Okay, and did you say Clark or Cobb County?
Clark, Clarke.
All right, thank you so much.
Yes, Your Honor.
And Ms. Tucson, anything in your system for Ms. Howard?
No, Judge, no record in portal.
All right, thank you so much. Mr. Arca.
Yes, Judge. This is an isolated incident, as you can tell. She has no prior criminal history. She just finished her degree. She's an educated young lady. Sometimes all of us experience a bad night. Again, that's why they call them an isolated incident. This is no reflection upon her. She's been an absolute pleasure to work with. She's been kind and courteous. As you can know, Judge, in this line of business, when somebody is kind and courteous with you, it goes a long way. I have no reason to believe that you're going to see her before your court or in another court at any time in the future. I think this is just one bad night, got the best of her. She's learned from her mistakes. She would like to do this under first offender to go ahead and keep her record clean. I don't think she's going to have any violations or any issues. I strongly believe that. And Judge, I just ask that you accept the plea as negotiated.
Okay. Ms. Howard, what did you get your degree in?
Sociology.
Great. Where'd you go?
Georgia State.
Okay. And you just finished, as in like you graduated or you like this
I
term?
graduated in May, but I'm in an intern right now for substance abuse. So
Okay. Where are you interning?
At AACS Counseling
Where's that?
in Marietta.
Okay, great. What was going on this night? Was it a celebration or something bad was going on in life or what?
Yeah, I actually went to a party and I actually had too much to drink. So
Sounds like it.
yes, and of course, all the things in the world was going on with the cops and stuff like that. So I took, you get drunk. So it just kind of, I overreacted.
Right. Your filter had gone away
Right.
because you had too much to drink. And so things that you might not say if you were sober, you said when these officers were trying to sort out what's going on.
Right. And I wasn't expecting, I was so drunk. I wasn't expecting, like I went back to the accident, like out of nowhere. Like I should have, I don't know. I just went back and trying to see about my car and I just went left.
Okay. First offender, I'm sure Mr. Arca has talked to you about it, but I need to talk to you about it on the record. It's primarily an opportunity for someone just like you, someone with no criminal history. If you enter this plea as a first offender, then it's not a conviction. You'll be what we call a first offender probationer. So you can look everyone in the eye and say, I don't have any convictions. If you're trying to get a job or get a graduate degree, and that question is, do you have a felony conviction? The honest answer is, no, I do not.
Okay.
And if you successfully complete your probation, then when it's over, it can all be expunged from your record. I don't know how that works. I just know it can happen. And you've got a lawyer standing next to you who can help you navigate that process. But the important part is it's not a conviction. You have pled guilty, but if I sentence you as a first offender, it's not a felony conviction.
Okay.
The downside of it is that if you have kind of pulled the wool over Mr. Arca's eyes and you actually on a routine basis go out there and carouse and are running into trees and poles, and 3 months from now, the officers roll up on you and you're passed out next to the car and you cuss at them and kick them and whatnot, we'll be back together. And I can revoke not just your probation, but I can revoke your first offender and resentence you as if you were a felon. And with these charges, I could sentence you to up to 10 years plus 24 months because it's 2 5-year sentences and 2 12-month sentences. I'm not saying I would do that. If you go shoot someone, I'm going to give you as much as I can.
Right.
But if we're misreading the situation and 3 months from now, something unfortunate happens and you're arrested and it's substantiated. So not a speeding ticket, but something serious. And you're in here, you just need to understand the downside, which is we're all disappointed. We misread the situation and you could lose your first offender status. And without a trial, because you've already said I did these things, you could be resentenced up to that maximum of 12 years. Understand the downside.
Yes, I understand.
Okay, understanding the downside and appreciating and desiring the upside, is it your choice, Ms. Howard, to be treated as a first offender in this case?
Yes.
Okay, great. Well, I find you understand the risks and the benefits of first offender. I will sentence you as a first offender. I find there's a factual basis for your plea, having looked at the police report and heard what Mr. Hand had to say. I also find that your plea is knowing and voluntary. Knowing means you've understood everything we've talked about, and voluntary means that you're deciding on your own, upon advice of counsel, that this is the right way forward for you. Is that correct?
Yes.
Okay. I will sentence you on count 1 to 1 year, count 2, 1 year, count 3, 12 months, and count 4, 12 months. Those will all run concurrently with each other, and they'll all be probated. So what it really means, if you mush all that together, is 1 year probation. It's felony probation. So you're actually going to meet a probation officer right now, and she's going to give you some reporting instructions. Special condition of probation number 1 is that you take an anger management course, and probation can help you find one, but you may know how to find one given the kind of work you're interning with. It's fine if you find it. You'll just have to provide a certificate of completion to probation. Check that box. Number 2, I wasn't clear whether the expectation is that Ms. Howard attend a MAD panel or that she participate on a MAD panel. Attend. Okay, that seems to make more sense because no one was in, I mean, an officer got kicked in the face, but that wasn't a result of the driving. So it's not like there was someone hurt by a drunk driver. So you'll also need to attend a MAD panel, and I guess there'll be some proof of attendance, checkbox 2. And then finally, and this seems the least necessary of the 3, but we might as well be careful. You'll need to submit to a drug and alcohol abuse evaluation. A professional will ask you a bunch of questions just about how you spend your time. And if any treatment is recommended, that treatment will become part of your probation. They may well determine that, look, you every once in a while you have a real good time and have too much to drink. That's not treatable. That's how people are. But an expert will have a conversation with you about that. That is special condition number 3. And that is it, I think, Mr. Hand. Anything else in terms of conditions of probation?
No, Judge.
Mr. Arca, anything else?
Nothing else, Judge.
Do you have any questions about anything we talked about, Ms. Howard?
One question about I know I'm going into the first offender, but if my job was to do a background on me, is this going to pull between this year because I am getting hired on in January?
Sure.
So is it going to show?
It shouldn't, because it's not a conviction. There'll be nothing. You heard me ask Ms. Jackson criminal history, and she said there was some arrest back in 2014, but there was no disposition. That disposition, if you had entered a guilty plea, not as a first offender, would show up if they ran your history, and it would say she has a conviction for obstruction or whatever this case would be. This should not show up. Okay. If for some reason it does, you should talk to Mr. Arca, because he can get you paperwork that would show this is a first offender, and it is legally not a conviction. Okay. And that's really what ought to matter. But when employers run these checks, they don't actually get to peer deep down into it. The check just scrapes your record and pulls off any convictions. And this isn't that. Okay. So you should be okay.
Okay, great.
All right.
Thank you.
Ms. Howard, do you authorize my staff to electronically sign the indictment indicating your guilty plea?
Yes.
Mr. Arca, can we sign for you?
Yes, Judge.
And Mr. Hand?
Yes, sir.
All right. Ms. Howard, last thing, I'm going to ask Ms. Toussaint to make herself visible on the screen there, and she's going to ask you a couple questions and give you some reporting instructions about probation.
Okay.
Good morning. Could I take down your phone number and I will give you a call? What county do you live in, Miss Howard?
Fulton.
In Fulton. Okay, so that means you will be reporting right up the street to our address on 276 Memorial. May I have your phone number, and I will retrieve your email address, and I will scan you over your reporting instructions to you. Yes. And if your attorney would like them as well, I could give them as well.
Yes. Sure. Phone number 404-384-3010.
404-384-3010?
Yes, ma'am.
Okay, I will call you shortly after you walk out just to get that information from you and give you the rest of the reporting instructions, and, failure to report will result in a warrant.
All right. Anything else, Ms. Howard?
That's it for me.
All right. Good luck with everything, with your budding career. I'm glad you've turned in that direction. We need more folks working in that field.
Thank you.
All right. You are free to go.
Thank you, Judge. I have no further business.
You may be excused. Thanks for being here.
Thank you, Judge.
All right. I am not seeing, I see Ms. Feely. Do we know where Ms. Wood went? Is she's out there. No, I know she's working.
She's sending, I'm sending.
Oh, you're sending me updates? All right, let's see what else is happening here. Ms. Duncan, are you still here? Hey, Ms. Duncan. So Ms. Wood tells me that whatever the offer was, you're not interested in at this point, and you'd like to have a trial. So your case will move, as we discussed, to that November 28th. That's that first business day after Thanksgiving trial calendar. So if you haven't resolved your case before then, I'll see you in this courtroom on November 28th. But Ms. Wood will be in touch with you, okay? All right. If that's all you got, you're free to go. You bet. Mr. Christopher, so it's my understanding that you're not saying no to the offer, but you need to think about it. You get it a little better? I don't know that it'll get better, but that's not my job. What Ms. Wood is telling me is that we'll move your case to the trial calendar, which is always the default. But it may well be that between now and then, either something better comes along, or you decide if that's as good as it gets, it's better than going to trial on a hit and run resulting in serious injury or death. Sometimes those are hard cases to defend against, but you and Ms. Wood will talk about that. Otherwise, I have this down as the 5th. Was that the preferred week, the second week, or the first week?
That's what I have, Judge.
Okay. All right. So you are free to go. You'll keep thinking and you'll stay in touch with Ms. Wood. All right. So let's do one more thing before we break for lunch, and then we can do many more things after my lunch meeting. I can either have that conversation with Mr. Porter, who he's pro se now, but he's been re-indicted. And so we need to arraign him. And then I have to have a mini Ferretta hearing with him. It's probably that'll fit best. But if there's a simple plea that you want to do right now, we could do the simple plea instead. But everything else we'll just need to do at 1:30 when I'm done with the case management meeting.
I don't have a plea ready yet, Judge. So.
Okay, it sounds like people need to talk to Mr. Hand. Ms. Primovic needs to beat him up. You need to chat with him, and we'll see where that goes. So I don't know which clients might be online. If there are folks, Mr. Jones is still on. If someone can reach Mr. Jones. Ms. Feely, I don't know if you're able to reach Danny Jones. He's still on. Doesn't need to stay on. I think that's it. There's a Mansur. I don't know who Mansur is. But why don't we let folks take their lunch break? So Ms. Jackson and Ms. Tucson, we'll see if you can log back on at 1:30. That would be great.
No problem.
Thanks. And Mr. White, now, I don't know if you have stuff left. If you do, we'll pick back up at 1:30.
No, Judge, it was just the Shar Grant case and Ms. Duncan, and then the Castillo matter. So I think that should be it.
Okay. Thanks for being here.
Thank you, Judge.
All right. Why don't we bring Mr. Porter out, please? And he should go straight to the podium. And what we'll do, Ms. Morgan's class, is handle this thing, and then we can talk a little bit. At 12:30, I got to go be on a Zoom call, but I'm going to meet with Mr. Porter, and then we can talk about what you've seen and questions you may have. And I asked the lawyers if they could stay too, because you may be more interested in what they do. They're the advocates who do the public speaking. I just sit up here and bang a gavel, except I don't have a gavel. And investigator, I haven't forgotten about you. We can, when we adjourn, you and I can have a little signing session. Hey, Mr. Porter, this way. How you doing?
I'm all right, and you?
I'm okay. I've got some news for you. I'm just calling it up on the screen and then we'll get on the record.
Okay.
All right, so Mr. Porter, I'm talking to you now about a new indictment, same case, but it was re-indicted. The new indictment number is 22 SC 184973, and we're on the record. You and I spent a good deal of time together last week or the week before. We had a Feretta hearing during which you made plain to me your desire to represent yourself.
Yes.
And you answered all the questions you needed to, letting me know that you were making a knowing, voluntary, and intelligent decision to represent yourself, despite the fact that I told you I think it's a bad idea. And it's one of the few times a judge is allowed to offer an opinion to a litigant. And you said, I hear you, Judge, but I'm in charge. And you are solely responsible for deciding, do you represent yourself or have an attorney representing you? The only thing that's changed is that Mr. Shapiro, the prosecutor, re-indicted your case to change the charges a little bit. So I need to rearraign you on the new charges, and then I need to confirm, we won't go through the whole conversation again, but I'll need to confirm that with these new charges, you still want to represent yourself. Okay?
I do.
Well, I bet you do, but you can't know that till I tell you. If I tell you you've been charged with 3 counts of murder and they're seeking the death penalty, you might say, wait a minute, I might want a lawyer for that. But that's not what you're charged with. Have you already seen the new indictment?
No, I haven't.
Okay. Well, let me get it up on the screen here. And I'm assuming you want to be formally arraigned like you were last time. In other words, I inform you of the charges.
Yes.
And then you'll tell me you'll enter your plea of not guilty and I'll get you to sign the indictment. In fact, I'm going to print it out right now. All right. While it's printing, Mr. Porter, you were indicted in 22 SC 184973, which is styled as a re-indictment of 22 SC 182626 with 3 counts. Each count is child molestation. Count 1 alleges that on or about August 8th of 2021, you did unlawfully commit an immoral and indecent act to Saria Wright, a child under the age of 16, by touching said child's genital area with the intent to arouse and satisfy your sexual desires. Count 2 charges you with child molestation. The allegation is that here in Fulton County on that same day, you did unlawfully commit an immoral and indecent act to the same alleged victim by touching her breasts with the intent to arouse and satisfy your sexual desires. Count 3 is a third and final allegation of child molestation. And the allegation is again here in Fulton County on August 8th, 2021. You did unlawfully commit an immoral and indecent act to the same alleged victim by kissing her, and that you did so with the intent to arouse and satisfy your sexual desires. Do you understand what the allegations are against you in this indictment?
Yes, sir.
They've changed. There was an enticement count about you supposedly luring this young lady somewhere. That's not in the indictment anymore. So you're not having to defend against that. And I think there was a sexual battery that has also, that's not in this indictment. So it's 3 counts of child molestation. I need to remind you that the penalty, should you be found guilty at trial of child molestation, is a range of 5 to 20 years in custody. However, it's my recollection that you have a prior child molestation conviction. And so the range, if that's true, and the state would have to prove that you have a prior conviction, but if they can prove that, then the sentencing range is 10 to 30 years or life imprisonment. So the state can request a sentence of life in prison. I'm not bound by that, but that's an option, 10 to 30 or life. And that would be for each of these 3 counts. So assuming you have a prior conviction for child molestation, you need to understand that the maximum sentence you could get if you were found guilty of all 3 counts would be 3 consecutive life sentences. I'm not saying that's what you would get. Obviously, a jury would have to find you guilty first, but it's important, as we discussed last time you were here, that you understand the worst case scenario, which in this case would be 3 consecutive life sentences. Do you understand that?
Yes, sir.
Okay. Understanding these new charges, are you entering a plea today of guilty or not guilty?
Innocent. Not
Okay,
guilty.
so innocent's not an option. It's
Okay.
not guilty.
Not guilty. Same
Okay.
thing to me.
Same thing as before. I'm gonna get you to sign this indictment. So we'll have that in writing. And I'll get Mr. Hand to sign it as well. We'll staple this. When we spoke before, you made clear that it was your desire to represent yourself. The only thing that's changed is that the nature of the allegations has shifted a bit. Has anything changed in your mind about representing yourself?
No, sir.
You still wish to represent yourself,
I do.
and you still understand the benefits of self-representation, which you were able to describe as you know the case better than anyone else,
Yes, sir.
and all the many, many risks of self-representation. Which include no assistance from a lawyer. Whoop, hold on one second. But you have a question?
The case number off of that.
How about I print out a second copy so you get another copy of the indictment? I'll do that. We'll print that out. But if you represent yourself as before, you won't have a lawyer helping you. You won't have a lawyer who can subpoena witnesses. If you remain in custody, which you likely will before your trial, all your research and investigation and preparation will occur within the confines of the county jail. You'll have access to the law library, but that's it. You understand all that?
Understand all
Good.
that.
You understood it before. And knowing all that, you would like to persist in representing yourself.
Yes.
Then I'll enter an order. I was about to enter the order in the older case, and then you got reindicted. And we thought, let's bring Mr. Porter back. Let's arraign him. We've done that. And as before, anything you file going forward will be a motion that I need to work through. You filed a bunch of motions when you had a lawyer, even though you told people back when you were arrested you didn't want a lawyer. And Mr. Shapiro and you and I will need to figure out what we're going to do with those. Okay?
Okay.
Any questions about anything?
Yeah. Last time I was here, we didn't deal with that in depth about this lawyer situation.
Well, we dealt with it real in depth. We talked for about a half hour about how you were going to represent yourself.
Yeah, but I'm talking about the lawyer that was given to me.
Okay. That you
against
didn't
my
want.
will, against my, without my knowledge or consent.
Okay.
I never asked for an attorney. And the day after I invoked my rights, they give me an attorney. Nobody ever told me about that. No lawyer ever came to see me. I have never talked to an attorney, period, for 11 months. So I never had an attorney.
So I thought what we agreed was that the motions that you had filed, I was going to treat as validly filed. Legally, if you've got a lawyer and it looked to everyone else like you had one, I appreciate in your mind, you didn't ask for one. You didn't realize one had been appointed to you. But what was in your docket was Fred Smith is your lawyer.
Understand.
Once you have a lawyer representing you, a defendant who files a motion, that motion is what we call a nullity.
Yeah,
Hey, you got a lawyer. Only your lawyer can speak for you in court.
Understand that.
But what I thought we agreed was that things you had filed, I will not treat as a nullity. So you filed a demand for a speedy trial. Well, I'll have to look at that, see if it was timely, if it complied. As I think we discussed, all speedy trials are told right now anyway because of the carryover from the pandemic. But that doesn't mean you didn't at the earliest point raise your hand to say, I want my trial and I want it now. And,
Exactly.
and we'll keep things moving along. Mr. Shapiro, who will be handling your case, has said, I'm ready. I think that's why he re-indicted. I think he dove a little deeper into the case file and realized, I don't know about this enticement charge, but I think there's some more child molestation in here. And so this is what we got. Okay, so you will need to come back here. I'll need to bring you back here sometime soon. Staple or no staple? No staple. All right. This is your indictment. So we can talk about those motions.
Okay.
So we'll do that. I just need to give Mr. Shapiro a chance to get up to speed on that, and then we'll bring you back here and have those discussions.
Then one more thing, Judge. At the jail, it's almost impossible to get the mail personnel to come up and pick up mail. So when I'm filing motions, if the mail lady don't come and get them, and then by the time she comes to get them or he comes to get them, and then they get here, and then they'll be filed late. Sometimes the mail lady don't even come, period, for a whole week. And then I file a motion. Then you say, oh, no, the DA say, well, we didn't get the motion in time. And it wasn't filed on time.
So what we'll do, in some ways, your motions are now late. Anything that would be filed would be late, but not in this case, because you were just re-indicted. I'm not going to worry. I'm not going to worry about those kind of deadlines. What we'll do is get you over here to talk about your older motions.
Okay.
And I'll ask you, is there anything else you're going to be filing? You know what, Judge? Yes, I've got this and I've got this. And we'll agree on a time frame for you to do it. And we may just bring you back so you can hand the motions in. I don't want there to be a game, whether it's caused by you saying like, oh, I missed the mail lady, or the mail lady doesn't come by. So we'll fix that. And it may just be that the way you file things is that you're going to go to that door right there and we take your motions and we file them. I don't want you to lose sleep over, oh, they're going to think my motion is late. But there will come a time when we are face to face and I say, we're done with motions. It is now time to argue those motions and then get you your trial. It's not that you can drip these motions all the way up to the eve of trial.
Gotcha.
Okay. Anything else?
No, sir, nothing I can think of at this moment. I'd ask the court to take judicial notice of all foreign law that I may bring up.
What kind of foreign law are you thinking about?
Different states.
Different states.
Yes.
Got it. Okay. So what I'd ask you to do is just save those kinds of requests until we're actually arguing motions. And then I'll probably say, hey, Mr. Porter, why are you quoting all this Wyoming law? We're in Georgia. And you'll say, because I think it's persuasive authority. And if I'm persuaded by it, then there you go.
Gotcha.
Okay. Mr. Hand, anything from the state in the Porter matter?
No, Judge.
All right, Mr. Porter, it's good seeing you again. You've got a copy of your new indictment. I will be making sure if there is other discovery that you should get, Mr. Shapiro gets it to you, and we'll take it from there.
Okay, because
Okay.
I resubmitted about 2 or 3 motions, and I sent them like last week. I don't even know if they've been filed.
Was it in the old, but you didn't have the new case number, right?
No.
So it would be in the old one. Let me check. Going forward, make sure you file things under that new case number because the state has null pros dismissed the older case. It doesn't exist. I mean, it exists, but they dismissed the charges. So the docket is there, but your filings haven't hit the docket yet. To your point, the mail moves slowly when you're in jail. Another disadvantage of self-representation.
Yeah, but for the life of me, I still can't figure out how does it take one letter 8, 9 days to make it from a county jail to downtown?
You know what? It may not take that long. It sticks at the jail for a while and it sticks here for a while. But either way, we may develop the hand delivery thing. Okay.
Okay.
All right. We'll see you.
All right.
Yes. Hello?
All right, the audio should be back on.
Judge, we're ready for you to go.
They are. Yes. Thank you for being here. We will see you hopefully before the trial date. That'll be a good sign. And remind me of the young lady who's still here.
Position 12, Ms. Saxon.
Oh, that's Miss Saxon.
Yes.
Okay, great. So Miss Saxon, what Ms. Wood told me is that right now there's still a little distance between whatever the state's offering and whatever you think is a reasonable disposition. So I told Ms. Wood, your case remains towards the top of the list for that first week of trials, which is the 28th, that Monday after Thanksgiving. So you'll want to stay in touch with Ms. Wood. But if she says, come on down, then that Monday, the 28th, you'll come right here and we'll figure out how to move your case forward. Okay. You bet.
Thank you.
So it's 3 pleas, 2 people, 2 for Fant and 1 for Mr. Jones. If we can find Mr. Jones.
Right, Ms. Feely, I just talked to him 15 minutes ago. I don't know if he went back to work.
It's Vegas.
It's Vegas.
Vegas. Although there it's can't be real hopping right now. People are just now like, oh, I'm waking up. All right, so I'm ready for whoever is next.
One moment.
You had mentioned to start yours.
Yes.
I have it set up 1:15. That work, or do you really want to on?
But just anything that is earlier is better because I looked at the calendar. I don't think it'll take that long to get through the calendar, but then stuff starts piling up. We'll be done with drug court. That won't be an issue. So starting at 1 or 1:15 is fine. Just at 3:30, some of the grand jury people are showing up to talk about things. And at 4, I have to be down in 1D for the JQC stuff. So I just wanted to build us as big a window as possible. And I just don't remember now that we're talking about it, what I'm looking at the calendar now. So plea and arraignment should go quickly unless there's a plea, but nothing wrong with that. Status conferences. Ricky Wolf. Mr. Batten, I just signed something for him. Just to get a computer in. So it's a medium length calendar. So the closer to 1, we can 1:15 is fine.
I can get the jail to make sure that they pull the people.
Oh, it's Zoom. It's jail Zoom.
Mhm.
Okay, let's just do 1:15. That's fine.
Okay.
I was wondering if your reaction was more like, well, I'm not sure Zoom will start.
No, my thing was because it's already them pulling the
Yeah.
people to make sure that
Yeah.
they have them.
Yep.
So
They usually have people there pretty early, so I may even try to get on at 1:10 and see what's ready. But
yeah,
we'll
you
see.
just wouldn't have your cameras ready.
The cameras, because they don't kick.
Our cameras will start. We can start theirs early, but our cameras are scheduled to start at 1.
I don't want to mess with that because, yeah, strange things happen. Excellent. No, no problem. You've been here all day. You're entitled to a quick break.
Right here.
So you all will try to track down Mr. Jones while we do Mr. Fant's 2 cases. Excellent. Just give me the high sign when you're ready, Mr. Hand.
That's just. Yeah, you're good.
I'm ready, Judge.
All right, let's make sure all systems are go with this system. They are good. Good afternoon, Mr. Fant.
Yes, sir. Good morning.
Good afternoon.
Oh, excuse me. I said good morning. Good afternoon.
All right. You've got 2 cases, 21 SC 177577 and 22 SC 182022. And Ms. Wood tells me you're prepared to enter pleas in both. Is that correct?
Yes, sir.
And we're going forward with both, Mr. Hand?
Yes, Judge.
Okay. In just a moment, Mr. Hand will put you under oath. Once you're under oath, make sure you answer all of the questions posed to you truthfully and completely.
Yes, sir.
And also, please make sure that if at any point you've got a question, because you can't hear what someone says, or it's just not making sense, that you let Ms. Wood or me know, okay?
Sir.
Excellent. Let's do it.
Yes, Judge. Judge, I don't know if you want me to give you the downgrades at the outset before I move forward.
Please do.
Okay. So for the first position, 5, the first count will be downgraded to criminal trespass. Right now, it's criminal damage to property in the 2nd degree.
Okay.
That criminal trespass is 16-721. That's the OCGA. And we're requesting a restitution hearing. Well, they're requesting a restitution hearing.
Okay.
For position 6, the first count aggravated assault will be downgraded to pointing or aiming a gun or pistol at another. That is OCGA 16-11-102. And the second count will be no pros as well.
So one lawyer on the defense side is okay with pointing a pistol, but the other is not. Interesting. All
I'll
right.
tell you more, Judge, as the facts come.
All right. Got it. Appreciate you framing it that way. Let's go.
Yes, Judge. All right, Mr. Fant, am I pronouncing your name correct?
Yes, sir.
Mr. Fant, please raise your right hand. Thank you. Do you swear or affirm that the statements or testimony that you shall give the court today regarding the matter before the court is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your true and correct legal name.
John Xavier Fant.
I'm sorry, say it again.
John Xavier Fant.
Okay. And are you at this time taking or under the influence of any medication, drugs, or alcohol?
No, sir.
Is there any medication that you would normally take that you have not taken today or been given?
No, sir.
How old are you, Mr. Fant?
28 years old.
And how far did you go in school?
I had attended Georgia Perimeter College.
Okay.
Associate's degree.
And can you read, write, and understand the English language?
Yes, sir. I hope so.
Okay. Do you understand that you have been charged in 2 separate indictments for different charges today? Those are for the first 21 SC 177577 with the charges of criminal damage to property in the 2nd degree.
Yes, sir.
Which the state is downgrading to criminal trespass, and for count 2, simple assault. And then in indictment 22 SC 182022 with the charges of aggravated assault with deadly weapon, which the state is downgrading to pointing or aiming a gun or pistol at another, and possession of firearm during the commission of a felony for count 2, which the state is also no prosing.
Yes, sir.
Which means to not prosecute. And do you understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about the charges and the indictments against you, including the facts and circumstances related to each charge?
Yes, sir.
Would you like more time to speak with your lawyer?
No, sir.
Are you satisfied with your lawyer's services?
Yes, sir.
Okay. Attorney Wood, do you waive the formal reading of the indictment for purposes of today's plea?
So waived.
And do you also waive any and all defects in the indictment for purposes of today's plea?
So waived.
Your Honor, the state is unaware of any outstanding warrants related to the charges in both indictments.
Okay.
Mr. Fant, do you understand the minimum and maximum sentence for each charge to which you are pleading today?
Yes, sir.
Are for criminal trespass is 1 to 12 months imprisonment, 1 day to 12 months. For simple assault, 1 day to 12 month imprisonment. For the second indictment, count 1, pointing a gun at another, it's 1 day to 12 months imprisonment, and then and that's a total.
Yes, sir.
Do you understand that today you're entering a negotiated plea, which means that the state will recommend the following sentence to the court? That recommendation is for the first position, count 1, a downgrade to criminal trespass, 12 months probation. For count 2, 12 months probation consecutive. No contact with Mackenzie Lee. Mackenzie is MACKENZIE. Lee is LEE. A condition of staying away from restaurant Super Rica at 1130 Avalon Boulevard. Is that your understanding for the
Yes,
first
sir.
case? Okay. And do you understand that the state intends to recommend for the second indictment for count 1, downgrade to pointing or aiming gun at another, anger management as a condition, while on 12 months probation, and to have no contact with Chapian Gavin.
Can you spell that?
Yes, Chapian is CHAPPIANNE, last name Gavin, GAVIN. Do you understand that to be the condition?
Yes, sir.
Okay. Do you understand that the court is not required to take the state's recommended sentence today?
Yes, sir.
And do you understand that the court has the right to run each of the sentence for each of the charges against you consecutively, which means one after the other?
Yes, sir.
Do you understand that the court has the right to sentence you to the maximum possible sentence for each charge?
Yes, sir.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, sir.
Do you understand that if you're currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? That includes municipal, county, state, or federal.
Yes, sir.
Do you understand that if you are on probation, if you are placed on probation, you must follow any and all special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of, in the first indictment, 21 SC 177577, criminal trespass and simple assault?
Guilty.
And how do you plead to the charges in indictment 22 SC 182022, pointing or aiming gun or pistol at another,
Guilty.
Okay. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
And for misdemeanor charges, do you understand that you only have 12 months from today to file this habeas corpus petition?
Yes, sir.
At this time, Judge, the state will give a factual basis for both cases before the court. So for position 5, if this were to proceed to trial, the state would show that on June 28th, 2020, at about 12:30, an APD officer, Mr. Ham, responded to a disturbance at 1130 Avalon Avenue, which is the restaurant Superica. Upon arrival, he spoke with the victim, who Ms. Mackenzie Lee. She stated that she and her boyfriend, who at the time was Mr. Fant, were sitting in their car in the parking lot of Avalon, the restaurant, and they got into a disagreement. At one point, she felt uncomfortable and decided to get out of the vehicle and to walk away from the situation. She noticed Mr. Fant also get out of his vehicle and follow her. She went into the restaurant, Superica, and asked the manager to not let Mr. Fant in. This is after the dispute. She then advised that Mr. Fant came inside after her. She then went into the women's room. He then followed her into the women's restroom, where he became angry and began tearing down the stall where she had barricaded herself in the restroom. Ms. Lee states that he broke the door on the stall, and then he entered. He began pulling at her, punching her, and then she stated she began to scream. At that time, the manager, whose name is Mr. Robert Pigeon, walked in to figure out what was going on. He entered and stated he saw Ms. Lee climbing over the middle of the two stalls, and inside was the defendant, Mr. Fant. He did not observe him assault her. He didn't observe him create the damage. He just saw them in that position. Once he entered, Mr. Fant left, and he followed him to the parking lot. He wrote down his vehicle number because he got in his vehicle and left at that point, and then called the police. Another manager, Mr. Kelly, was also an observer. And that's all I have, Judge.
Okay.
For that factual basis. For the second case, Judge, it occurred June 19th, a week earlier, but this time at a bar, Churchill's Bar, at 3223 Canes Hill Place, Northwest. At that time, the defendant was in a car with another young lady, Chappie Ann Gavin, whose name I spelled for the court earlier. They were sitting in an SUV. She was, Ms. Gavin was in the driver's seat. A female acquaintance was in the passenger seat. And it's my understanding Mr. Fant was in the back. They were having a discussion. They had some drinks. They were sitting in the SUV, and there was a disagreement also. Ms. Gavin stated that Mr. Fant was showing her initially his pistol, and she was fascinated by it, but then became argumentative over the subject that they were talking about. He became irate and then pointed the pistol at her chest and stated, "I don't care, I'll stand up for what I believe in." Ms. Gavin looked at her chest and saw that there was a laser dot on her chest coming from the gun. And at that point, she exited the vehicle. They all exited. Ms. Gavin went inside the bar and told an employee of the bar what happened, that someone had just pointed a gun at her. That person was, sorry, look at his name. Mr. Larkin, sorry, he was an employee of the bar. He went outside, saw Mr. Fant roaming around in bushes. He asked him, what was he doing? He said he was looking for his gun, which he had dropped in the bushes, and his cocaine. Those are statements that he made to Mr. Larkin. Mr. Larkin said he'd help him find it, but then he went and called the police. The police arrived. At that point, Mr. Fant was detained. His car was around the corner, so officers located his car, secured a search warrant, searched the car, and found a gun that did have a laser on it. It was a Smith & Wesson 9mm pistol under the driver's seat, and it had attached to it the laser that I discussed. In the trunk, there was a black backpack with different things, one of which included empty marijuana packages, marijuana residue, but most importantly, a baggie of 0.4 grams of suspected cocaine. He was detained at that time. Nothing further, Judge.
Mr. Fant's not charged with any drug-related offenses.
He's not.
Okay. And is your recommendation a total of 36 months because one case runs consecutive to the other, or it's a total of 24 months because that's what you get from the first case?
36 total, Judge.
Okay. All right. Ms. Jackson, good afternoon. Thanks for rejoining us.
Good afternoon, Judge.
Do you have any criminal history information for Mr. Fant?
Yes, I do, Judge. The defendant has 8 cycles. The defendant's last arrest was June the 19th, 2020, with the City of Atlanta Police Department for aggravated assault and possession of cocaine. I think that possession of cocaine was not prosecuted. It says on April the 18th, 2022. But there were no convictions or no other information on what happened with the aggravated assault. No convictions, nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, any active probation for Mr. Fant?
No, Judge, just the case that ended in 2020. So he's not on probation at the moment.
What was the case that ended in 2020?
Let me go back to it.
Judge, it should be a first offender that he successfully completed.
Okay. That didn't come up with Ms. Jackson.
It's 18 SC 162192.
Okay. Ms. Jackson, is that on your radar at all?
It's not listed in the GCIC, Your Honor.
Okay, maybe because it was, but it should still be in the GCIC. Interesting. Yeah, it's all sealed up here. I tried to look at it on Odyssey and it's locked. So maybe it got it expunged.
Yes, yes, sir.
Well, there you go. That's what can happen after a first offender. It's the expungement is working. Okay. Thank you both for that. Ms. Wood.
Thank you, Judge. I want to start by pointing out that both of these are from the summer of 2020.
I've noted, in fact, a lot of our cases, it's interesting, a number, maybe all our pleas today, maybe not Ms. LaSalle, maybe so, were from the 20s, but they're 2022 indictments, which doesn't bode real well for the poor DA's office if what they're indicting now is bond cases from 2 years ago. But I know they're working through a big backlog and I appreciate their focus.
So yes, Judge, so Mr. Fant has not had any other issues since then. For the 21 SC 177577 case, I did just want to point out, we spoke with Ms. Mackenzie Lee. She told our office she's over this incident. It is well behind her and she was not inclined to come to court or any of that. Like Mr. Hand stated, there were no other witnesses to this incident. And so that is why, while we feel like we would have a good chance on this one at trial, in the spirit of judicial economy, Mr. Fant wanted to move on with his life and enter this plea to this misdemeanor. For 22 SC 182022, there was actually another friend involved in this one. Mr. Fant maintains he was never being aggressive to Ms. Gavin. She's actually a friend of that friend. He was having this discussion over the gun with his friend, and then Ms. Gavin came in on board. And so again, he's eager to resolve with these misdemeanors, but he did just want to let the court know that he was in no way being aggressive or planning to use that weapon in any form. Judge, he's 28 years old. He lives in the metro area. His whole family lives here. He does have an associate's degree from Georgia Perimeter. He's been gainfully employed for the past 7 years as a project manager with Shock Theory. We would only ask that, well, we ask for the restitution hearing, of course, and then if the court would consider suspending the probation after a period of compliance. Otherwise, we would just ask that you accept the state's recommendation.
Okay. Was Mr. Fant on first offender probation in June of 2020?
I'm not sure, Judge.
Yes, sir.
Okay. So you shouldn't have had a gun then. First offender probationers are not supposed to have guns. But it does sound like June was a complicated month for you 2 years ago. And since then, there haven't been a lot of issues.
Yes, sir.
Ms. Wood, in speaking with Ms. Lee, does Ms. Lee say nothing happened, or she said what happened happened and I don't choose to revisit it?
Judge, she didn't get into the facts with me. It was made clear that they were together back then and they haven't been together for a long time, and she's eager to not ever talk about it again.
Got it. Okay, understood. Mr. Hand, the restitution would be restitution for Superica, not for Ms. Lee or Ms. Gavin, but it would be if in fact the stall door was torn off or damaged in some way in the women's restroom at Superica. That's what the restitution would be about?
There was a stall destroyed in the process.
Okay, hence the criminal damage to property in the second degree. It's not Ms. Lee's property, it's Superica's.
Yes.
Okay. Mr. Fant, during this time in your life, June of 2020, were you struggling with drug use you couldn't control, or were you just a recreational user? I want to be clear, I'm asking not to get you in any more trouble, just to make sure that if you need assistance, you're getting assistance.
Oh, no, no, sir. I'm not gonna lie to you. I did smoke a little bit of weed, but I'm very anal about not doing anything else.
Okay.
Because that's the main thing, and I kind of made up with Mackenzie too as well. So we're good, and we kind of look both different ways. So we're good.
And Ms. Gavin wasn't a significant other of yours.
Oh no, Ms.
just
Gavin,
a late,
she's a random.
okay, random person.
Yes, sir.
Okay. What is Shock Theory?
My mom owns a marketing company that does large scale events for like multi-level marketing companies. Mm-hmm. So she'll like rent out like the Smoothie King and like Las Vegas, all that, and do like large scale events. And she's the executive event producer. So I just been kind of doing the video project management, just anything she really needs help, because she's kind of gonna give me the business when she gets old. So
that's a good gig to have.
Yeah, so I just kind of was a little going through it back then. So
okay, but you're still doing Shock Theory work.
Yeah,
got
yeah, that's forever.
Okay, all right.
That's my mom's business forever.
There you go. Okay, well, Mr. Fant, if you don't have any other questions, I find that there's a factual basis for both your pleas. It is a little peculiar that they happen so close together in time, but it sounds like there were other things going on. I'm glad to hear you and Ms. Lee have made amends, even though you're heading in different directions.
Oh, yeah.
I also find that your pleas in the two cases are knowing and voluntary, meaning you've understood what we talked about and that no one's forcing you into these pleas, but that you've decided whether it's judicial economy or your own best interest that you want to go forward with the pleas. Is that correct?
Yes, sir.
All right, then I'll accept them. On the first case, the one ending in 577, I will sentence you to 12 months on count 1, which has been reduced to criminal trespass, and 12 months on count 2, which is simple assault. I'll run those consecutively to each other, so it's 24 months.
Yes, sir.
It's all probated, and it will be a special condition of your probation in that case that number 1, you stay away from the Superica restaurant at the address that we heard Mr. Hand share, which is 1130 Avalon Boulevard in Alpharetta.
Yes, sir.
And you'll also need to take an anger management course.
Yes,
probation can help you find that course. You'll need to take that.
Okay.
In 22 SC 182022, Count 1 has been reduced to pointing a pistol at another. Count 2 has been dismissed. I'll sentence you to 12 months on count 1, probate it and run it consecutive, meaning after your sentence in the case ending in 577. So overall, it's 36 months probation. And you'll have to have no violent contact with either Mackenzie Lee or the Chapion Gavin.
Yes, sir.
And if you are doing fine after the first 18 months of probation in the case ending in 577, I'm okay with probation saying, let's make it either non-reporting or they may choose just to wrap it up.
Yes, sir.
And that would have the effect then on the case ending in 022 as well. Mr. Hand, anything else in Mr. Fant's cases?
No, Judge.
Ms. Wood?
No.
So Mr. Fant, you are going to get contact information either from Ms. Wood, or you may even get a call directly from misdemeanor probation.
Okay.
You may have heard Ms. Tucson, who's on the Zoom call. She does felony probation.
What's the difference?
So one difference is felony probation. It's a government entity, the Department of Community Supervision. When people say probation, that's what I typically think of. And so there's actually a deputized law enforcement officer who has a badge and has a gun who's supervising you, because that person could arrest you if you are violating probation.
Okay.
Misdemeanor probation, Fulton County has privatized, so it's a company that does it. You will have a probation officer who may be a little less present in your life than a DCS officer, but that's not
being the
Department of Community Supervision.
Yes,
so the felony supervision.
Yes, sir. I get it now.
You won't have that. You will have, because you were on felony probation
Yes,
for a
sir.
while. This misdemeanor probation, it's with a private entity. They may have you come into their office rather than someone knocking on your home door. I don't know exactly how they
Came to the one right here down the street. I think it was, I just always was just coming in and like once a month.
Right. And that was through DCS, the
Yes, sir.
felony probation. This will be different.
Okay.
Private company, they may have you dial in or who knows what.
Yes, sir.
My point is simply, they'll be contacting you soon, either through Ms. Wood, or because you give her your contact information, they may reach you directly. And it's important that you plug in with them up front so they don't come to me early on to say, Mr. Fant's not showing up. We can't find this guy.
Sir.
But once you are connected with them, they can begin the supervision. You can do the anger management and be on your way.
Yes, sir.
Okay.
Thank you.
Last thing I've got, do you authorize my staff, Mr. Fant, to electronically sign your 2 indictments indicating your guilty pleas in those cases?
Yes, sir.
Ms. Wood
Yes, Judge.
and Mr. Hand?
Yes, Judge.
All right, I think that's it.
I'll take these two.
You can have those for your kids.
Pointing a pistol is 16-11-102, according to Mr. Hand.
All right, thank you, Judge.
You bet. Good luck with everything.
Okay, you're welcome. You're welcome.
So,
He's on, Your Honor, Mr. Jones.
yep. Are you okay if I remove Mr. Jones, not your Mr. Jones, but Danny Jones?
He does not know how to get out of the meeting.
All right, he is about to, but we will not report him. He's not being removed for that reason. He's out. All right. And then before we start with Justin Jones, I noticed some Lumases joining. Hello, Lumases. I want to make sure you know that we've already talked about where did he go? Delon Lumas, his lawyer dialed in at the beginning of the calendar, which was more like 9:30 this morning. And we are resetting Mr. Lumas's case to January because according to Mr. Butterfield, Mr. Loomis's family is raising the funds for an expert to evaluate Mr. Loomis, to assess Mr. Butterfield, to assist Mr. Butterfield in the sentencing when Mr. Loomis enters a plea. So you're welcome to stay on, but I just noticed a few Loomises, and we're not going to talk about that case again. And Mr. Loomis himself has already gone back to the county jail. All right, Justin Jones. let's get you going. Somewhere on here, number 16. All right. Can you hear us, Mr. Jones?
I'm sorry.
Can you hear me?
Yes, Your Honor, I can hear you.
Excellent. Oh, it looks like you're in uniform now. Are you at work right now?
I am. I was actually on a task. I left my phone in the office, and I apologize for being a few minutes behind. I'm still trying to get used to Pacific time, and 1:30 your time is 10:30 my time. So I was about maybe 5 or 10 minutes late. My apologies.
No worries. We took up some other business and now we'll take up yours.
Sure.
So Mr. Jones, before we'll get on the record in your case. It's State versus Justin Jones, 22 SC 180844. Before we start the plea conversation that we need to have, I need to make sure that you are willing to waive your right to be physically present here in court. You've got an absolute right to be present in open court so the whole world can see you and you can see the whole world, but you can waive that right and appear remotely. Are you waiving your right to be present?
Yes, Your Honor. Yes, I am.
You also have the right to have Ms. Primovic actually there with you so you guys can huddle up and confer if something comes up. But Ms. Primovic, much to her dismay, is not in Las Vegas. She's in Atlanta, Georgia. So if you guys need to confer, you have to let me know. She can step outside and she can give you a call. Are you comfortable proceeding with Ms. Primovic here in Atlanta and not with you in Vegas?
Yes, Judge. Yes, I am.
But do let me know if you want to speak with her in confidence and we'll make that happen, okay?
Sure.
All right. Mr. Hand is going to put you under oath right now. Once you're under oath, be truthful in all your answers and we'll go from there.
Sure thing.
All right, Mr. Jones, if you could raise your right hand for me so I can see it in the camera.
Sure.
Do you swear or affirm that the statements that and testimony that you shall give today in the matter currently before the court is the truth, the whole truth, and nothing but the truth?
Yes, I do, Mr. Hand.
Okay, thank you. You can lower your hand.
Sure.
Please state your true and correct name for the court.
My full name is Justin Gregory Jones.
And are you at the moment taking or under the influence of any medicine, drugs, or alcohol?
No, sir, I am not.
Is there any medication that you would normally take that you have not taken or been given today?
No, sir, I am not. No.
How old are you, Mr. Jones?
I am 30 years old. I'll be 31 December 6, 1991.
And how far have you gone in school?
Associate's degree.
Can you read, write, and understand the English language?
I believe I can. Yes, sir.
Okay. And do you understand that you have been charged in indictment 22 SC 180844 with 2 counts, 1 count being aggravated assault, which the state will downgrade to disorderly conduct, and then possession of firearm during commission of a felony, which the state will not prosecute. Is that your understanding of what your charges are?
Yes, sir.
And do you understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir, I do.
Do you understand that if you decide to plead not guilty or remain silent or refuse to enter a plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, I do understand.
Have you had an opportunity to review your rights with your attorney today?
Yes, I have.
Have you had enough time to speak with your lawyer about all of the charges in today's indictment, including the facts and circumstances around each charge?
Yes, sir, I have.
Would you like more time to discuss your case with your attorney?
I believe that my attorney and I had some good conversation, and I think we've accomplished what we needed to. So I don't think at this time more time is needed.
Are you satisfied with your lawyer's services?
Yes, sir, I am.
Okay. Attorney Primovic, do you waive formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects in the indictment for purposes of today's plea as well?
Yes, sir, we do.
Okay. Let me just double check. Okay. Judge, the state is unaware of any warrants related to the charges in today's indictment.
Okay.
Mr. Jones, do you understand that the minimum and maximum sentence for the charge to which you will be pleading guilty today is 1 day to 12 months imprisonment?
Yes, I do.
Okay. And do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? That sentence is 12 months suspended sentence, the condition of staying out of Georgia, except for Clayton County, which is where the airport is located.
And to keep a job.
And to remain employed. Is that your understanding of what the conditions are?
Yes, sir.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, I do understand. Yes, sir.
Do you understand that the court has the right to sentence you to the maximum possible sentence today?
Yes, I do understand.
Do you understand that if there are multiple charges to which you're pleading guilty, which there aren't, but if there were, the state could run the court could run those consecutively, meaning one after the other?
Yes, I do understand.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, I do understand.
Okay. Do you understand that if you are currently on probation or parole, that your probation or parole may be revoked based on you entering a guilty plea?
Yes, I do understand.
Do you understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit, those being municipal, county, state, or federal?
Yes, I understand.
And do you understand that if you are placed on probation, you must follow any and all special conditions of that probation?
Yes, I understand.
Do you understand that if you fail to follow any special conditions of your probation, you will be subject to revocation of that probation for the balance of your sentence?
Yes, I do understand.
And do you understand that if you're placed on probation, you may not possess or use a firearm during the probationary period?
Yes, I understand.
Okay. Are you a United States citizen, Mr. Jones?
Yes, sir, I am.
And do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, sir, I do understand.
Do you understand that by pleading guilty, you are giving up the following rights? Those include the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial.
Yes, sir, I understand.
Is it your decision to waive these rights, which means to not use them, and enter a plea of guilty today?
Yes, it is, sir. Yes. Mhm.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Of the disorderly conduct, yes.
But he needs to answer.
Of the disorderly conduct, Mr. Jones,
Yep.
not of the original charges. How do you,
Understood.
are you
Yes.
guilty?
Yes.
Okay. Do you need me to repeat that, Judge, or is that?
No, I understand it. And I think the record shows he's pled guilty to the reduced charge of disorderly conduct as to count 1, and count 2's been dismissed.
Yes.
Yeah, I'm sorry about that. That one kind of tied me up a bit because I wasn't sure, but I understand now. But the
Okay.
answer is yes.
How do you plead to the charge of disorderly conduct in indictment 22 SC 180-844?
Guilty?
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
And is this, do you understand that you only have a limited right to appeal this guilty plea?
Yes, I understand.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, I do understand.
Do you understand that for a misdemeanor charge, you only have 12 months from today to file this habeas corpus petition?
Yes, I understand.
Okay. At this time, Judge, the state will give a factual basis for the plea. Whether it's to proceed to trial, Judge, the state would show that on July 10th, 2021, officers responded to 565 Main Street regarding a dispute involving a firearm. Upon arrival, officers spoke with the victim listed in this case, Ms. Taya Famulario, Famularo, who reported that she was working on duty, garage security, Judge, and the defendant, Mr. Jones, attempted to exit the wrong way out of that parking garage. He was seen in a white BMW trying to exit. The defendant, Ms. Famulario, told him, hey, you can't go out that way. He began to yell at her and then asked a female who was sitting in the passenger side of the vehicle to grab his gun. At that point, the defendant had a gun in his hand. He pointed it at the victim and proceeded to tell her that if she stepped any closer, he would have the right to shoot her. At that time, the defendant, Ms. Famulario, grabbed her phone. She took pictures of the tag on the car, and then she called 911. When the police arrived, she told them what happened. She did give them a picture of his license plate, which is how they were able to track it to him. The vehicle was registered to him. The state will, acknowledge there was no surveillance cameras in the parking garage. However, there was a witness, Mr. Luis Reyes, who did corroborate Ms. Famulario's statement. A photo lineup was used with his driver's license, and Ms. Famulario did positively identify the defendant as the one who assaulted her. Arrest warrants were issued, and the defendant was apprehended July 18th, about a week later, Judge. The victim did not have any video footage of the actual incident, but those are the facts of the case, Judge.
Okay. So walk me through why you think this is a reasonable outcome, assuming, and I may hear about weaknesses in the state's case from Ms. Primovic, but assuming for a minute, Mr. Jones pointed a gun at this woman simply because she said, you can't go out the entrance to a garage. He thinks it through, give me my gun, gets the gun, points it at this person. That's a felony. I can understand downgrading it if we learn that Mr. Jones hasn't done something like this before, but a suspended sentence, I mean, there's effectively no consequence to having pointed a loaded gun at a woman who was simply doing her job. Super dangerous situation. What if she had taken a step forward? Does he kill her? I mean, it's so a little alarming, and we're saying just don't come back to Georgia. So maybe you can point a gun at someone in Nevada instead. I haven't heard the defense side, but I'm trying to put on the prosecutor hat. Why just a suspended sentence?
Well, Judge,
and I know you were going for pointing a pistol at another, and that's not how it shook out.
I agree, Judge, which are both misdemeanors.
Right.
Judge, there was no gun recovered. There is certainly enough beyond reasonable doubt to show that there was a dispute happening between the two.
Did the gentleman, I'm sorry to interrupt you, but you said there was a witness.
Yeah.
Did he say, I also saw the gun, or he said, I heard the beef?
Judge, there was no direct statement that he saw the actual gun, but that he did see them in a dispute in the parking garage.
Got it. So it boils down to a he said, she said, and maybe I'm going to hear that, well, I know Mr. Jones got a job. He's relocated. He's working hard. So there may be reasons to say, let's just hope this doesn't happen again.
Yes, Judge.
Okay. All right. Ms. Jackson, any criminal history for Mr. Jones?
Yes. The defendant has 6 cycles. The defendant's last arrest was November the 19th, 2016 in Pennsylvania for simple assault, reckless endangerment, and terroristic threats act, and robbery. Some of those charges were no pros, the reckless endangerment and the robbery. It was no pros on June the 14th, 2017. I didn't see anything for the terroristic threats, but he did receive a misdemeanor conviction in 2017 for simple assault. Nothing in addition, Your Honor.
All right, thank you. Ms. Tucson, any active probation for Mr. Jones?
No, Judge, I see no entries in portal with the given information that I have for him.
Got it. Thank you. All right, Ms. Primovic.
Thank you, Your Honor. Mr. Reyes, who is the witness that was also in the parking lot, did see the whole verbal argument and both parties cussing at each other, yelling at each other, but never saw a gun. We had our investigator, and I have that written, it was being transcribed today, as a matter of fact, getting ready for trial. He never saw a gun. And
so he was not just an ear witness, he was close enough to see who is doing what, et cetera.
And could probably pick out my client that that's the guy.
Yep.
This is the car he was driving
Yep.
in. The complaining witness, Ms. Familaro, when the police officers came, the body cam video is her just going off and on and on and on. You have her social media where she just has some anger issues. I'm not saying my client doesn't either. And he admits he cussed her out, called her, the B word, I'm sure, and did some things he should not have done.
But that's disorderly.
That is disorderly. And we had the conversation that if we have gone to trial, we would probably ask for that lesser included.
Mhm.
So he was going to get that anyway,
Yep.
from my opinion. And the odds are not good that he would get 12 months suspended. And I appreciate the state. He is out of the state now. He has moved to get a job last week. He told me it's the best job he's ever had. He's a beverage manager for every bar and lounge in Mandalay Bay, owned by MGM. He is still in the training now. He trains from 8 to 6 and 10 to 8, or 10 to 8 p.m. And he's really, really excited about this opportunity in his life. And he regrets not being a very kind and nice person to this woman. And he really appreciates what the state has done. And since he's out there and he has his life established, the state was willing enough to suspend it with, don't get caught in Atlanta for a year or arrested again, or and maintain a job. He's going to keep a job. That's not a problem. He's always had good jobs. That's not a problem.
Okay.
And he does not own a gun. That's why I was so adamant about the pointing a pistol. He does
Sure.
not like guns. He never owned one. And so that's why I was pretty adamant about that. And that's one of the first things he told me when we spoke.
I'm not a gun guy.
I'm not a gun guy. It's not what I do.
Good. All right, he'll live longer. Mr. Jones, anything you want to add or any questions you've got about what we've been discussing?
No, I'm just very thankful that that you're first of all considering this offer, and that the state has given me an opportunity to just live my life and have a second shot without this lingering over my head. I'm very, very grateful, to say the least. I'm very happy, and I just really feel blessed, honestly. And I thank everyone, from you to the state to my attorney, for just having my back and allowing me to even get this opportunity to put this behind me. So I'm just very grateful for the opportunity and my job. It means the world to me. Frankly, it's the best job I've ever had. I'm required to work 50 hours a week. It's definitely the hardest job I've ever had, but I guess great things doesn't come easy. So I'm very excited, and I'm just really, really thankful for this opportunity.
Well, you're welcome. Most of the heavy lifting was done by your lawyer and by Mr. Hand. I'm just on the receiving end of their good efforts.
Sure.
Mr. Jones, I find there's a factual basis for your pleaded disorderly conduct. Sounds like Ms. Famularo might have been arrestable for disorderly conduct as well, but you were, and here you are. I also find that your plea is knowing and voluntary. You've understood what we talked about. No one forced you to enter this plea. You're doing it of your own free will. Is that correct?
Yes, Your Honor.
Okay, I'll accept it. I will follow the joint recommendation, and to count one, which has been reduced to disorderly conduct, I'll sentence you to 12 months, but I'll suspend those 12 months. I'm going to give you the 2 conditions, but it's not like I can enforce it unless you actually were, for example, to walk into this courtroom, because one condition is stay out of Georgia except for Clayton County. And that's simply because you may have to fly somewhere and a plane lands at Hartsfield. That's in Clayton County. It's fine to transit that way. But don't leave the airport and leave Clayton County. If you end up in Fulton County, where we are now, that would be a violation of your suspended sentence, and the state could seek to revoke the balance of your suspended sentence. And the other condition is the easier one, and that's keep a job. You have a great job right now, and yes, it's a lot of hours, but it's some serious responsibility. And you start out at beverage manager, and in 3 years, you're general manager, and you're running the Mandalay. Who knows what'll happen there? So I wish you the best. Stay in Nevada or any other state except for Georgia for a year, and give us a report on how you're doing.
I will do so. And again, I really thank everyone. I really appreciate it. This means the world to me that this no longer has, lingering over me in my career, because, this could have caused me to lose my job. So I'm very happy, I got this out of the way. Thank you very much.
Mr. Hand, anything else in Mr. Jones's case?
No, Judge.
Ms. Primovic?
No, Your Honor.
All right, Mr. Jones, you are free to go. If you want a copy of this final disposition, just be in touch with Ms. Primovic and she can email it to you, okay?
Sure thing. Thank you, Your Honor.
You bet.
Okay.
Take care, Mr. Jones.
You're all set. You can go back to work.
All right. Thank you. Bye.
All right. Thank you, Ms. Tucson. Thank you, Ms. Jackson. Got a few pleas here with your help, and we'll see what happens with trial.
Okay, no problem.
Thank you, Judge.
Bye-bye.